Ms. D. Gregorio, I can see you're here. And, Ms. Norton, do you appear for all the defendants?
All defendants, yes, Your Honor.
Perhaps call Mr. Kuksal, Ms. Zhu and Mr. Ansel outside, if you don't mind. No appearances? We were told they might be running a bit late. It's now after 11:15, though. Ms. D. Gregorio, is there anything sort that just concerns you and the defendants?
So, I did want to withdraw from the…
If you don't mind just standing up, yes.
I did want to withdraw from the proceeding, and I do have agreement with the defendants about withdrawal. The other plaintiffs haven't responded to me, so I'm seeking the court's leave to withdraw.
All right, so do you want leave to file a notice of discontinuance?
Yes.
Ordinarily, that would come with it an obligation to pay costs. Ms. Norton, is it the situation that
We consent for there to be no order as to costs as between Ms. D. Gregorio and the defendants.
All right, well, I will. So Ms. Norton, what's the form of order I should make?
I thought it was perhaps a notice of withdrawal, Your Honor, that might be the appropriate mechanism, but…
Yes, I think that is probably right. So I will grant leave to the second plaintiff. You can take a seat, Ms. D. Gregorio. Thank you very much, the second plaintiff, to file a notice of discontinuance. And what do I…
Well…
Have you got a copy of the order?
I have sent in a draft of consent orders, which we've agreed. I apologize, Your Honor. What has been agreed on behalf of the defendants and Ms. D. Gregorio is that she have leave to discontinue the proceeding as against the defendants.
So just grant leave to, I will just say, to discontinue the proceeding.
And, 2, there be no…
Well, I think I should make an order that is discontinued by you filing a notice of discontinuance. You will have to file a form. So I grant leave to you to file a notice of discontinuance of the proceeding, and I will order that there be no costs as between the second plaintiff and the defendant.
So just one question, Your Honor. Registry has previously knocked it back because I've only got the signatures of the defendants. So how do I deal with the registry?
Well, I have given, I think, let us know if there's any problem, but I will provide to you in the course of the next little while an order granting you leave to file a notice of discontinuance.
Thank you, Your Honor.
Thanks, Ms. D. Gregorio.
So only one other matter. I notice that the summons refers to sums on behalf of the plaintiffs. It includes me as one of the plaintiffs. That is not the case.
Yes.
I have no interest in the summons or the way it has been formulated.
Yes, I understood that to be the case, and I think there's a footnote somewhere that indicates that Mr. Ansel has got this.
I just want to make sure it is clear.
All right, thanks, Ms. D. Gregorio. As far as I'm concerned, you can, from now on, participate or not as you wish.
Thank you, Your Honor.
That's right, isn't it, Ms. Norton?
Yes.
There's no concern.
No concern, Your Honor.
All right, so as I say, you're free to go or to stay. Up to you. Now, Ms. Norton, I suspect you've seen the summons that was filed yesterday.
Yes, Your Honor. Would you like me to briefly address you on the defendant's position on those matters?
Yes, though bearing in mind you might need to repeat it.
Well, if I can begin this way, Your Honor. The defendants are here primarily to argue their summons, the summons that we filed in November of last year.
But no written submission.
No, we rely on the written submissions that we filed in December last.
All right.
Has Your Honor not got a copy?
Not,
They were filed shortly after the summon was filed. They're very comprehensive submissions.
I had not.
Dated the 18th of November 2022. They were prepared at the time by Mr. Senatharaja and Ms. Kerwin, who were acting for the board.
All right, I will get those sorted out. They had slipped by the wayside.
Yes, I understand, Your Honor. Apologies for any confusion.
All right, no, it's very kind of you to apologize, Ms. Norton, but I suspect it's a wrong apology in that sense that it is not.
I couldn't say it any better than counsel formally briefed by the board, so we rely on those written submissions.
All right, I will get those. I do have a sense that it would. Can I also clarify? Have you, one of the orders I made on the previous occasions, was that the plaintiffs, speaking loosely, file, so what was set down for hearing today was your client's summons and the first 3 paragraphs of the amended or further amended summons of the plaintiffs, and I ordered them to file affidavit material and written submissions by a date long gone.
Yes.
Have you received any written submissions?
No, Your Honor.
All right.
And in circumstances where we haven't received written submissions and for reasons that are developed in our summons and with submissions we don't understand what's put against us and we say it's improperly brought. We haven't prepared our own submissions, but I am able to address Your Honor orally in relation to paragraphs 1 to 3 today.
All right, the difficulty is, so does your strikeout application seeking a strikeout of every paragraph?
Yes.
Including 1 to 3?
Yes.
All right, I'm not clear and I'll have to hear from them, quite what material they say is relevant to paragraphs 1, 2 and 3 and what material they're saying is relevant to their recusal or various other applications.
Yes, I think it would be of great assistance to have that clarified.
Yes. Have you seen an affidavit that's been circulated but not yet filed sworn by Mr. Ansell this morning?
I understand that my solicitors have it, but I haven't had an opportunity to review it.
Yes, you better perhaps should have a look at that. I've only had a quick look at it myself. It is, I think, focused on the recusal application, and it is saying that there's material that they want to rely on in the recusal application, so they want to have that brought about first. My inclination, subject to hearing from you, is that I probably ought to entertain the application they're making for recusal before I go on to consider your client's dismissal application.
Well, if the recusal application is brought on in some kind of proper basis, I suppose we were surprised and yet not surprised to receive it yesterday in circumstances where Your Honor has recently as a week ago ruled on a recusal application.
Well, those are all reasons for which it may or may not succeed.
Yes.
The question is,
I appreciate that it would be.
They have filed a summons. They're seeking that order, and I think I ought to hear what they've got to say about that.
I appreciate that, Your Honor. I wouldn't stand in the way of that.
That means I probably should stand the matter down for half an hour. What is it now? Maybe I'll stand it down until 11:15.
Yes, Your Honor.
That will give you an opportunity to look at that affidavit, and it will, hang on. I'll be able to find those summonses. So in terms of your client's application, there's no affidavit material relied on, it is just.
There is an affidavit. Again, that was filed around the time of the application.
What's the date of that affidavit?
An affidavit of Mr. Ernst dated the 30th of November 2022. It's a very brief affidavit that exhibits the various instruments of appointment of the second to fourth defendants. I had hoped also to take Your Honor.
Affidavit of Mr. Ernst the 30th of November?
Yes, Your Honor.
Okay, yes.
I had hoped to take Your Honor to a few further documents which aren't exhibited to Mr. Ernst's affidavit but which I have understood would be in evidence as they're exhibited, it would seem, to affidavits that the plaintiffs have filed in the proceedings. Unfortunately, it seems those exhibits haven't been filed, and so I'll just give some consideration to how we might deal with that matter.
Yes.
It may be that if Your Honor's content, I can piece the documents together as best as I can.
What are the documents? I'm not sure that it will work well if you are trying to rely on exhibits to documents by the plaintiffs, because those exhibits, as I say, they have not all been filed.
Yes.
And some of them are voluminous.
Yes.
Are they controversial documents?
I don't. Well, the fact that they were issued may be controversial, but they are what they are. That is, it's the 3 interim compliance audit reports that Mr. Naylan, the second defendant, prepared in his role as auditor appointed by the board, and there's a management system direction that the board issued to the firm.
Yes.
And 2 letters from the board to the firm in relation to the appointment of Mr. Naylan and also the management system direction.
All right.
It may be, I'm in Your Honor's hands as to how to deal with that. I was working overnight on the basis of an affidavit that Ms. Di Gregorio had served on the board at some point, which did exhibit all of these documents and include the exhibits, but I've discovered this morning that that document hasn't been filed.
And this is your application, and so such evidence as you're relying on would have to be produced, I would have thought. You can't assume that another party is going to lead evidence on it.
Yes, I appreciate the difficulty, Your Honor.
All right, well, thanks for that. Mr. Kuksal, it is 11 o'clock. The court started, the case was listed for 10.30. Mr. Ansell has been the one communicating with my chambers. Is not here yet, and Ms. Zhu is not here yet. Do you know when they're likely to turn up?
Yes, Your Honor. I actually came with them, and there is an admission on in the courts today, so there's around 50 people standing at the entrance to get into the court building, and there's no parking either. So they're in fact dealing with those issues, and I ran too.
So when do you think they will turn up?
In the next 10 minutes at the most.
Should I stand it down until 11:15?
Yes, but I would just like to advise the court about the reason for the delay. I think I previously sent an email to the court about.
Should I stand it down until 11:15?
Yes.
And expecting everybody to start later.
Your Honor, several days ago I had advised the court that I had a conflicting matter.
Yes.
That I was trying to coordinate with the cross-court.
Yes.
And I would keep the court updated about the progress of that matter. And then this morning, unfortunately because the Commissioner was the respondent in that matter.
Yes.
It required a number of things to be dealt with. Mr. Ansell, who had prepared the billable costs, was then also required to stay back.
Look, it doesn't much matter at the end of the day. My concern is that it not become an ongoing practice that we lose half an hour every day. Look now, let's deal with what we have to deal with.
Sure, I just wanted to understand what has happened in the time that we weren't here.
I granted Ms. Di Gregorio leave to file an order of discontinuance with no order as to costs, and I've had a discussion with Ms. Norton about their application. They wish to proceed with her client wishes to proceed with her application based on the submissions and affidavits filed some time ago.
Yes.
And I raised with her that before working out what should be done and when, I should hear from you about what you've got to say about the refusal application.
Okay.
I clarified that the affidavit sworn by Mr. Ansell, circulated but not yet filed this morning, had found its way to Ms. Norton, but she had not yet had an opportunity to have a proper look at it, and I clarified from her that neither you, Mr. Ansell, nor Ms. Zhu have complied with the directions relating to the filing of submissions and the like in support of paragraphs 1 to 3 of your further amended summonses.
Because we've complied with the evidentiary requirements.
Have you?
Yes.
Has it been a submission? I haven't seen a submission saying that what's listed for hearing today are the first 3 paragraphs of your summons and amended summons, which are seeking to establish that the appointment was pursuant to for an improper purpose.
Yes.
And it should have ceased at certain points. You were ordered to provide submissions in support of that application.
Submissions in evidence?
Yes.
Evidence was filed long ago.
And what about submissions?
We will make them orally if that.
No, well, that's not acceptable, Mr. Kuksal. You were ordered to provide written submissions. How is anybody meant to deal with them if you just make them orally?
Your Honor, everybody's required to know what the law is, and we have filed extensive evidence in relation to those matters which Your Honor has documented in Your Honor's orders, several of those orders.
Well, at some stage we'll have to, when it comes to identify what particular evidence you're relying on.
They're identified in Your Honor's orders, yes.
But why did you not file a submission as directed?
Because, Your Honor, as Mr. Ansell's affidavit this morning clarifies, and before I go on further,
I should note for the transcript.
Yes.
That Ms. Zhu and Mr. Ansell have just walked in.
Yes, and Ms. Di Gregorio needs to be here as well. She's not.
No, she's
been given leave to file a notice of discontinuance the court will have to hear. We object. And she's not been given.
I've made that order and I've granted her leave to go as she wishes.
But she's still a party in this proceeding.
Yes, but she's not here at the moment. She said, I've granted her leave to file a notice of discontinuance. You're correct that she hasn't yet filed that notice, but
we weren't heard about that, Your Honor.
She's not obliged to be here. She's not bringing an application.
Your Honor, her affidavits are being relied upon.
Right, well,
we weren't heard in relation to this.
Let's cross, Mr. Kuksal. You weren't here.
Yes, but we had advised the court of.
Mr. Kuksal, I've made the order, I've granted her that leave. That's the end of that matter.
So may I clarify what leave was granted exactly?
I've granted her leave to file a notice of discontinuance and that there be no orders to costs as between her and the defendants.
You've made that order that there will be no orders as to costs? Or have you given her leave to file a summons that seeks that order?
No, I have made that order. I have granted her leave to file a notice of discontinuance and ordered that there be no costs as between her and the defendants.
Sorry.
Mr. Kuksal.
Your Honor, I'm clarifying what order has been granted. So the first order.
I haven't given her leave to file a summons. There is no further application by her being made. She and the defendants have reached an agreement that they will agree to an order that there be no order as to costs against her and that she be granted leave to file a notice of discontinuance. As you'll be aware, ordinarily if you file a notice of discontinuance then there's a costs order against the person who files the notice, but that's subject to a court making an order to the contrary.
Sure, but the first order that the court has granted is for her to file a notice of discontinuance.
Yes, I've given her leave to do that.
Okay, that would obviously need to be heard and decided.
No.
Once it's filed.
No, it's filed and will operate. The moment that's filed, her proceeding has been discontinued, her claims.
How could?
She will no longer be a moving party in the proceeding.
But Your Honor, she hadn't even filed the summons. How can the court hear a matter, besides the fact that we were late for advertised reasons, but the fact is that we weren't even aware that this matter would be heard today?
Oh well, it's been done, Mr. Kuksal. Let's deal with the.
But Your Honor, I'm just noting this for the transcript because it will be an appeal point.
All right,
There, at no point was the court clear to us that this matter could be heard. It was not on summons. We were asked to file summons. Yesterday we filed summons for directions, then we were asked to file summons for a contested matter.
Mr. Kuksal, you are seeking orders that affect other people's.
And her orders affect other people. The liability will be transferred to us. She was a very active participant in the proceedings. She's filed copious amounts of evidence in this proceeding which the defendants will have to peruse, and the cost of that will go on to us. There are liabilities. She was very active in the appeals that were raised, more so than Mr. Ansell was, and the liability of all of that would fall upon us. And this matter specifically had been addressed in the related proceeding 03994, in which we had also advertised to Your Honour our opposition to her removal.
Yes.
And the court, it cannot be reasonably said, could not have anticipated our opposition to the matter. We had also,
Mr. Kuksal.
Given, I'm noting this for the transcript, Your Honour, I should be able to.
No, you don't. There's no point. You can appeal my orders.
Yeah, but I need to know.
No, you do not have to. You do not have to put all your appeal arguments on the transcript in this matter.
No, I need. What I want to put on the transcript are factual matters.
Why?
Because they're not in the record of this proceeding.
Yes, but you can put them in the court. You can tell the Court of Appeal. If you want to appeal my grant of leave to her to file a notice of discontinuance.
No, it's not that, Your Honour. You have already ordered, you have made a self-executing order.
These are all matters, Mr. Kuksal. I made the order, you can appeal it.
But also I need to.
But there's no point.
Understand what the order exactly is. I know one aspect of it, which is that the moment she files a summons, it will automatically take.
It's not a summons, it's a document, a notice of discontinuance whereby she is one of a number of plaintiffs. She is discontinuing her claim.
She never filed summons to have that matter heard.
No.
So the court also gave her leave to have that matter heard without notice to the parties.
Well, I didn't, not in terms.
But implicitly.
Well, we discussed it here this morning, and
it was not on the agenda, though.
No, all right.
Yesterday she had sent an email to the court.
Mr. Kuksal.
Your Honour, I'm clarifying matters.
Enough. This has been done. You can appeal me or not, but you can't just sit there and continue to make complaints and criticisms here. The place to criticize what I've done is in the appellant court, all right?
It's also going to be a basis of refusal, the refusal application.
All right.
So,
all right.
May I just clarify one other matter?
Well, first of all, we've got the two things that were listed to be determined today, which was the defendant's summons and the first 3 paragraphs of your amended summons. And then you have filed summons.
Summons, which have been sealed and authorized by the court.
Yes, yesterday. This is the one seeking.
Yes.
Release from confidentiality obligations and amended, leave to file an amended originating motion, and the recusal application. And I've seen an affidavit, sworn by Mr. Ansell this morning, which may not have been filed yet, but
It has been.
Assume that will be filed.
Has it been filed? I'm told that it has just been filed.
Okay.
Now, Your Honour,
Now, should I hear from Mr. Ansell?
That is, yes, but, as is clarified in all his affidavits and his correspondence, he was making those correspondences and drafting those affidavits on behalf of all 3 plaintiffs.
Not all 3, 3 of the plaintiffs.
Well, all 3 natural persons that are plaintiffs at the moment.
But not Ms. Di Gregorio.
Well, she's not here anymore.
But the affidavit explicitly says that the reference to the plaintiffs.
Yes, I mean to exclude her.
Yes.
But what I meant was that
the 3 of you.
Your Honour has effectively, she's not participating in the proceedings anymore, so anyway, it's on behalf of Mr. Ansell, Ms. Zhu, and myself.
Yes.
And
is it the same argument on behalf of each of you?
Yes.
All right.
And
so it can be presented once.
To the extent that some people may wish to add to it.
So it's not the same argument for each person?
Your Honour, it is essentially the substance of the argument, in great part, is the same. There are additional nuances that parties may wish to contribute to.
All right.
But there's no one person that can effectively speak for everybody to the extent that no one would have to speak again.
All right. So the first question, it seems to be, is the request which emerges from the affidavit to rely on certain additional material in the recusal application.
Yes, but before that, may I just clarify one other issue? Yesterday, Ms. Di Gregorio had sent an email to the court and copied us in, asking if the court will allow her to raise the matter of her extrication from this proceeding. We did not respond to that email because we were waiting for the court.
I don't know if I will find out if I responded. If we responded, you would have been copied to it.
So, no, I'm saying the court did not respond.
Well, we may not have. My chambers does not spend its day communicating informally, in this sort of way, with litigants in every case in its matter.
No, you.
It's not you cannot just send emails to chambers, and then demand or expect replies in
I am not.
urgent timeframes.
I'm doing nothing of the sort, Your Honor. What I'm clarifying is that that email was not responded to, so we did not have any basis to conclude that that application which she was seeking leave to be heard about had been granted or even acknowledged by the court.
All right, so you've got an appeal point there.
Yes.
Now, let's move on.
No, not just appeal, but that would be relied on.
All right,
For the recusal application.
noted.
Okay, now, what the reason why Mr. Ansell's affidavit was, a fresh affidavit was sworn this morning is that yesterday, in the afternoon, following the lodgment of the initial lodgment of the summons and the affidavit, Mr., or I should say, Senior Constable Oni, who is the informant in the proceeding, Magistrates Court Proceeding M10047659, which has been extensively referred to in various documents filed in this proceeding, he disclosed a number of documents which ought to have been disclosed, according to the law, at least back in February this year, in the current proceeding, which is the committal proceeding, and last year, back in May or thereabouts.
So these were disclosed yesterday?
Yesterday, following explicit warnings from the Magistrates Court.
And they were disclosed by the prosecutors, or by the magistrate?
By the prosecutors, owing to their obligations of disclosure under the Criminal Procedure Act.
Yes?
Section 110.
And you say that the documents that have been disclosed are
Yesterday.
relevant to the recusal application?
They are indispensable.
All right, tell me what they say. The documents.
I am bound, Your Honor will need to release me from the Harmon undertaking because…
Well, I'm not going to release you from the Harmon undertaking. You have to get release from the court.
This court is, as we had raised in the…
But how do I know what's going on in the magistrate's court? It seems to me, Mr. Kuksal, that if you've received documents in the course of the magistrate's court proceeding, then if you want release from Harmon undertakings, you should be obtaining the relief from the magistrate's court. How do I assess what the implications of granting relief from that undertaking are for that proceeding?
Okay, if I could just make…
That must be right, mustn't it?
No, may I just address the court uninterrupted for 5 minutes about this? And I have prepared some submissions specially on the subject, and there is case law about it as well.
So the material, I'm trying to get this straight in my head. So you're being charged with criminal offences in the magistrate's court.
Well, I don't accept that as a matter of law.
Yes, but as a matter of form. I know you say everything is invalid.
Practically, there is a proceeding that purports to be a criminal prosecution.
Okay, so there's what purports to be a criminal prosecution of you, and is the magistrate's court.
And the Supreme Court, Justice Ginane is considering whether, in fact, that proceeding is real.
Okay, but the apparent proceeding, a document purporting to be a list of charges has been served on you, and
a purported charge sheet.
And what is the magistrate's court doing? It's considering whether to conduct a committal.
It has commenced, purportedly, a committal proceeding which was to culminate on the 29th of November.
All right, yes.
Unfortunately, because
that has gone off for some reason, I gather.
Yes, and that had something to do with orders that Your Honor made, as well.
All right.
In relation to the cross-examination of Ms. Anaz.
All right.
So, Your Honor,
So without disclosing to me material that's caught by the Harmon undertaking, is there any of the material that was disclosed yesterday that reflects on the way I have conducted the matters that have been before me?
Okay.
Is that capable of being answered, whether yes or no?
It is, but I'm just noting that I had previously asked if I could get 5 minutes uninterrupted to address the court why it can actually make the order for the release, but I'll get back to that question later. I'll answer what Your Honor has.
Okay, no, I'll give you 5 minutes to do that now, Mr. Kuksal.
Thank you. Now, Your Honor, the basis of the Harmon undertaking is not a personal interest that any particular litigant has. The basis of the Harmon undertaking has been clarified in this country in various court judgments, of which Hearn v. Street is one of the more prominent ones. The citation for that is 2008, 35 CLR 125. The purpose of the Harmon undertaking is to foster public confidence in full disclosure to the court of all matters that the court considers may be of use in achieving justice in a particular proceeding. It is because of this underlying public interest that the Harmon undertaking is an excessively technical ritual, and it does not look to the particular benefit, the material benefit, that is, or material prejudice that particular parties in a proceeding may encounter. Those are matters that are relevant to the consideration of the extent of fault or the punishment that must be meted out for the breach of Harmon undertaking if one, indistinct. But the principle is strictly enforced for the sake of maintaining the tradition where litigants in the proceeding have confidence in the court's ability to protect their private interests once disclosure has been made. And also to prevent other parties from creating mischief of the sort that seeks to discover documents in proceedings not for the purposes of those proceedings but for some ulterior motive. In this particular case, we have evidence that was exhibited Mr. Ansell's affidavit of yesterday that.
Can I say none of those? I haven't seen any of those exhibits.
This morning some exhibits were.
Yes, I haven't seen them, I'm just saying.
Okay, but they have been filed and we can produce them. And much of that is audio recording, so we will be able to.
How voluminous are those exhibits? If you added them all.
They are very voluminous.
So if you added them all together to the nearest 1,000 pages, how many?
I haven't done that exercise. I'd say they would be in excess of 2,000.
In excess of, is that?
2,000 pages, but there's also multimedia files. But we can specifically take the court to the relevant evidence, which will not take very long.
So how many pages of the affidavits would you be taking me to? Of the exhibits, rather.
That, Your Honor, really depends on how many questions Your Honor will have for me in response.
All right.
But if I may just get the.
Let's finish with the 5 minutes.
Yeah, I will need additional time for that.
Can I just note for the transcript that although I've said that we have a copy of the affidavit that's been prepared this morning by Mr. Ansell, we don't have copies of any of those exhibits.
No, I think the exhibits were to the earlier affidavit.
The affidavit of yesterday.
Yes.
Yes.
I see.
Yes.
So there are no exhibits to today's affidavit.
Yes.
Okay, so I'm going back to what I was saying before answering Your Honor's questions. In this particular matter that is the only proceeding, the prosecution is not objecting to the admission of the evidence of the documents into evidence. They are specifically disclosed for the purpose of adduction into evidence. The purpose of the Harmon undertaking is to protect the documents once they are disclosed under some sort of compulsion to protect them until they are either adduced into evidence or read out in open court.
Yes.
Or some authorities they referred to adequately in open court.
Yes.
Now, the undertaking is specifically engineered for circumstances where a party has been forced to disclose material that it is confident is not relevant to the proceeding and will eventually, once the court hears its objection, be discarded and not be admitted into evidence. And in the interim, that party should be assured that even if they reveal these documents that may be capable of causing them some harm despite their lack of use or possibility of use in the current proceeding, they should, nonetheless, be confident that the court will ensure that they do not suffer unfair prejudice and that the secrecy of confidentiality of the documents will be maintained, given that they are not relevant to the proceeding. In our case, the prosecution is not contesting to their admission into evidence. Because the Harmon undertaking is a highly technical ritual, the dilemma that we're in is that the documents cannot be adduced into evidence until the next hearing of the magistrate's court. But it's merely a sense of technicality, and in this particular instance, the Supreme Court has an obligation to consider what is just in the circumstance. That obligation comes from S85 of the Constitution of Victoria, which explicitly gives this court jurisdiction in every matter that is being contested in any court or tribunal in this state, unless it is specifically prevented from having jurisdiction in that matter by specific statutory provision. So this court, Your Honor, currently has jurisdiction in the only proceeding. And the magistrate has no more information about those documents. The magistrate hasn't seen those documents. And because it's a summary jurisdiction.
These documents have come from the prosecutor.
Yes.
Does the prosecutor know that you're seeking leave to get relief from the Harmon undertaking this morning?
It was foreshadowed to them that these documents would be used in this proceeding.
So have you told them that you will be trying to get an order from the court releasing you from the Harmon undertaking this morning?
No, but they were told.
Do you know what their attitude is?
Yes, they don't have a problem with. I know them specifically because one of the documents that they're relying on.
All right, so if it's going to be uncontroversial, why wouldn't you get the relief from the court in which the undertaking's given?
Because the court will not schedule a hearing for the release from the Harmon undertaking for the purposes of another proceeding.
So is the prosecutor consenting to the release from the Harmon undertaking?
The parties can't consent to the.
Okay.
It's only the court. It's a highly technical.
All right.
And, Your Honor, it's worth noting that the main documents that we wish to rely on, which we had foreshadowed that we will be making this application about, the prosecution is willing. They have raised no objection to their adduction into the public record.
What are the main documents?
Well,
No, not their content, but.
I know, and I am just phrasing matters succinctly. So, essentially, there's correspondence between the Legal Services Board and Victoria Police. Everything that I'm telling Your Honor is something that was discussed in open court, so I'm allowed to reveal this. So this is addressed in the correspondence that Mr. Ansell had sent to the court on the 30th of November, which is exhibited to his affidavit of yesterday.
We haven't got as I say, I haven't got the exhibits of yesterday, but yes.
But the court has responded to that email, so
Yes, it might have, that's right. I'm just saying I don't have it right in front of me now. But that doesn't matter. Tell me, what is the material, what is the relevance that the Harmon undertaking material is going to have to your recusal application?
So, Your Honour, the material goes toward a conspiracy between Victoria Police and the Legal Services Board. And it was specifically disclosed by the magistrate.
So the material supports your contention that the Victoria Police and the Victorian Legal Services Board were conspiring to cause you and your colleagues harm.
Well, specifically to achieve an unlawful prosecution.
Okay.
Of me, and.
So how does that make your recusal application stronger than it was a couple of weeks ago?
Your Honour, I hadn't finished. So the purpose of the conspiracy is, effectively, to get to an advantageous position in respect, while I would say unlawfully achieve a position that mitigates the Legal Services Board's liability in relation to the proceedings that I have brought against them. That's the first purpose. The second purpose is that it gives them grounds to preclude me from any involvement in the operation of a legal services entity. And I say commercial involvement. So I'm currently a shareholder, the sole shareholder of a law practice and of a company that runs a law practice, rather. And the Legal Services Board says that they have deregistered that entity from practicing law in February.
Yes.
In any event, if they were right, which they're not, all that is required by the legislation is that a lawyer send them notice to practice, and then they're bound to register it as a legal practice so long as the lawyer has the right certificate, which is a principal practicing certificate. So what they want effectively to do is to stop me from employing lawyers, effectively, not necessarily hiring, which they're also trying through different means, but the main agenda is to stop me from employing lawyers through a corporate intermediary for the purposes of essentially running an entity that participates in litigation on a commercial basis.
Yes.
Or
if a director of a company is associated with you.
With me.
With you.
Or owned by me.
Yes.
Now, this is specifically done, we say, because 1. I have brought several proceedings against the LSB in this court, and I have foreshadowed other proceedings which I would have brought after the disclosure of relevant material, some of which has already occurred. So the current proceedings were a means to understand the situation better, among other things, addressing the wrongs. And the second issue is that I have a strict policy of bringing relevant litigation against legal practitioners who I form the view have breached their ethical obligations or have committed some other malfeasance. Now, that again then created an interest in the legal services industry to exercise their capacity to lobby certain members in the Legal Services Board to stop me once and for all.
Yes.
And I have specific evidence of this issue.
Okay.
Now, the way in which we say there will be a miscarriage of justice if we are not allowed to adduce that evidence, and if Your Honour's not with me, I will need to cite the specific authorities for that, is that, firstly, the extent of prejudice or harm that is being caused by Your Honour's inadequate consideration, to put it euphemistically, of the specific factual issues in dispute and the harm that's coming from them. One example of that may be that in Your Honour's first judgment in this proceeding or first reasons in this proceeding published on the 23rd of August, Your Honour notes, where's my I need the reasons binder. So Your Honour notes that the takeover of the practices affairs by the LSB on the 22nd of August was documented.
The reasons you're referring to, which proceeding were they in?
This proceeding.
The
citation for the reasons is 2023 VSC 495.
Let me just.
And I refer to paragraph 2.
No, I can't open that at the moment for some.
It's a public document anyway.
I know, I've looked at it.
So it's number 2023 VSC 495.
495.
Published on the 23rd of August. Your Honour's reasons.
Yes.
Now,
This was on the appeal from the Judicial Registrar.
Keith.
Yes.
Yes, it's paragraph 2. I can just read the relevant part of paragraph 2.
Yes.
So, paragraph 2, on the 9th of November 2021, the Victorian Legal Services Board appointed Mr. Damien Nayland to conduct a compliance audit of the law practice operated by People Shop Pty Limited, Erudite Legal. On the 10th of May 2022, the board issued management system directions to the firm. On the 18th of August 2022, the board appointed Mr. Gordon Hooper as an investigator into suspected offences in connection with the firm. On the 20th of August 2022, the board appointed Mr. Howard Rapke as an external manager to the firm pursuant to power given by S. 334 of the Legal Profession Uniform Law. Your Honour then footnotes the specific, act in which that power is set out. Then, on the appointment of Mr. Rapke, persons were unable to participate in the affairs of the practice except under his direct supervision. Then Your Honor cites the specific section of the Act that entitles the Board to achieve that effect. And then Your Honor notes, relevantly,
I've got the paragraph.
on the 22nd of August 22, Mr. Rapke, with the assistance of the Board, entered the firm's premises and took possession of its files and other assets. A current affair filmed these events. Now, Your Honor could have only known this if Your Honor had gone through Ms. Di Gregorio's affidavit in detail, because this is not a public matter. In fact, it was not even covered in the A Current Affair broadcast.
Is it correct what I've said there?
Yes, absolutely.
Okay.
But what I'm saying is that the only way Your Honor could have known this is if Your Honor had extensively perused the affidavit of Ms. Di Gregorio, which was affirmed on the 21st of December 2022, and its various exhibits, and watched the YouTube videos, the links to which were embedded in the body of the affidavit.
Yes.
Now I would like to refer to some of those videos. This is the recusal application.
Yes, but a minute ago we were dealing with the argument that you need to get a release from the Harmon undertaking to properly present the recusal application, and I was asking you how it is that that reflects on what I have done or haven't done.
Yep, and we're still on the subject. I was giving Your Honor an example of how the ignorance of that material will essentially prevent the court from adequately appreciating the extent of injustice that will be affected upon the plaintiffs in this proceeding. And whenever I use plaintiffs in this proceeding, for the record, I will exclude Ms. Di Gregorio from consideration.
Just the three of you.
And the firm. I'm speaking on behalf of the firm.
Well, I'm not sure about that, because it doesn't have a lawyer, a solicitor here. But that probably doesn't matter.
Yes.
Yes.
But I am, so, Your Honor, there are sections of the Corporations Act which require third parties, including the court, to take notice of factual matters when they're made on authority from the firm. I am authorized to allow myself to make representations.
But the question is whether I've behaved in a way that might lead the lay observer to think that I might not be an impartial mind for hearing these matters.
Yes.
So what you're doing is you're identifying evidence which will more powerfully, you say, convey the impact that the misbehavior of others has had on you and your colleagues' lives, careers, whatever.
No, so.
But how does that affect my ability? Well, why does that mean I should recuse myself now?
Because the decision to recuse or not, like a lot of other decisions that require the exercise of discretion, are decisions that involve balancing a number of criteria.
I'll accept for the sake of argument it's a discretion. It may not be a discretion.
I agree with Your Honor, it's an evaluative judgment.
Yes.
But then my argument holds even more force.
Yes.
It requires the evaluation of various criteria. One of those criteria is the extent of prejudice that may befall. So, for instance, I'll give an example. If, let's say, this morning Your Honor were entering the court after some mishap with Your Honor's car, and Your Honor was absolutely parched, and I offered Your Honor a drink and Your Honor accepted it. That even though Your Honor had accepted a material benefit from me, the extent of bias that may be reasonably apprehended would be different if the same drink was accepted in a gold cup, which Your Honor kept afterward.
Yes.
So the extent of prejudice, the extent of influence, in that example, is relevant. What we're saying here is that if, for instance, another, slightly more relevant example would be if a person was sitting in the highest appellate court for criminal appeals and the decision being made was whether a person should be acquitted following a guilty verdict. The extent of distance that's required between the judicial officer and all relevant issues under consideration as they may interact with the judicial officer outside of court would be, in that case, the highest, more so, as a policy than, let's say, if in a magistrate's court, a dispute over a $200 bill was being adjudicated. So what we are saying, that these are matters of life and death that the evidence confirms, and the gravity of the context in which the recusal application is being made will not be sufficiently clear if the court does not allow us to adduce the evidence. And I would also say that
So I just want to get this clear. The point of the evidence is to show how strong your claim is against the VLSB and other people, and to show how significant the impact on you this proceeding potentially has.
No.
But
it is to show that actions that Your Honor has, we would say, erroneously attributed to lack of proper consideration by the LSB, such as the service of the summons and other matters, the evidence will show were tactical decisions that were made to disrupt these proceedings, including what we say are improper contractual arrangements being made with Ms. Di Gregorio.
Sorry, actions of mine have made.
Yes, Your Honor just granted leave to Ms. Di Gregorio.
Well, that's a different point.
No, we're saying that they have.
No, but.
That
just.
Can you stop doing that, please?
Yes,
No, I can't. Can you?
No, I think, Mr. Kuksal, it is capable of being, and I'm sure you don't mean it this way, but you are, it's capable of Ms. Norton feeling like you are trying to physically intimidate her, just because of the proximity of your standing and your pointing, so, I accept, you didn't mean it that way.
I'm not even looking, or
I know, but just as I see it, you speak in a very strong and loud, definite voice, directed at me, and if you lean forward and point at her, when you are just next to her.
Not her, but her side of the table.
Yes, well, I can see, you've, very appropriately, if I may say so, shifted the
lectern.
Material and the lectern a little bit.
Yes.
So actions have been you say that actions of mine were made to disrupt the proceeding in the.
No, I'm saying Your Honor has failed in the court in fulfilling the court's duty to prevent the LSB from perverting the course of justice, including this morning. We have evidence of Ms. Di Gregorio breaking down in tears and crying because she had no faith left in the court's ability to hold the LSB to account.
Okay.
And saying that she has given it a year, enough is enough, and her marriage will break down, and so on. That evidence has been served on various parties.
I'm just trying to make a note, failed to fulfill the duty of preventing the perversion of justice by holding the VLSB to account.
Or preventing them from perverting the course of justice, protecting us in our effort to.
Okay.
So
this is the third application of this type brought in recent times. What has changed since the last two?
Well, Your Honor, we keep, with due respect, because Your Honor has queries and obviously it's in my interests and the plaintiff's interests for me to address them. But the manner in which they're raised means that we keep shifting from one thing to another.
All right, but, Mr. Kuksal, well.
May I?
Can I say this? It's because you are talking and saying things, and I don't understand the
I accept that.
Overarching point that you're trying to make, so
I accept that, so may I?
Washes over me, and it's very hard for me to
I accept that.
Grasp it in my hand, what it is you're saying.
I accept that. May I suggest that Your Honor raise your queries as Your Honor does and I write them down?
No, let's just keep going. But I think it is helpful if you explain to me. I understand. So far, I understand you to have said that you've got a very good claim. The material that has been released more recently makes your claim even stronger. It will demonstrate that the VLSB has been acting inappropriately, with a view to try to harm your conduct, to harm your interests. I have not properly appreciated the extent to which the VLSB is misbehaving, and I have failed to prevent the VLSB from misbehaving.
I think, Your Honor, that trivializes, with due respect, the matter. What I'm trying to say is that, taking specifically the example from this morning, Your Honor granted Ms. Di Gregorio leave before hearing us, even though the matter was not foreshadowed as, something that would be decided today. In fact, Ms. Di Gregorio herself, in her email, hadn't said that she expected this to be decided today. The issue is that Your Honor may have looked at it and thought that both the plaintiff and the defendant, in this case, are agreeable, and in a normal circumstance, that application would be granted, so Your Honor may have thought that, in order to utilize the allocation of time in the best possible way, and leave enough time for the plaintiffs to raise their issues later, let's get the procedural matter out of the way.
Yes.
And decide that. Now, that would be true and innocuous for 99 out of 100 proceedings that Your Honor may face as a commercial judge or as a judge.
Yes.
Dealing exclusively in common law matters. But the context in which these proceedings are being litigated is that the LSB, in our assertion, which we say we have evidence to back up, has committed criminal offences, indictable criminal offences, that have to deal with interference in police investigations, and that have to deal with perversion of the course of justice, contempt of court. And a lot of those matters have been focused on intimidation of my witnesses and my co-plaintiffs to prevent them from successfully prosecuting these proceedings and related proceedings. Those are criminal matters. It's no different than them hiring goons, standing some distance from the court, preventing people from physically accessing the court. Ms. Di Gregorio's extrication from this matter is another example of that. We have documented the.
Would you have said she's not allowed to discontinue her claim?
Yes.
All right. So why would that not be an attempt to intimidate or influence a plaintiff, to say, even though you are acting for yourself, and you don't want to bring the claim anymore, we're going to not let you stop doing so?
No, that's not what it is, Your Honor. That is a consideration before someone starts a proceeding. Once a proceeding starts, the relationship of all parties is different. These are incontrovertible matters.
So you say that you couldn't discontinue this proceeding without Ms. Zhu's consent?
No, that's not what I'm saying. What I'm saying is that I couldn't discontinue this proceeding as a plaintiff without the court hearing about the prejudice that Ms. Zhu will face if I take that decision.
All right.
Because it was my decision to start the proceeding with Ms. Zhu. The law is what it is. It did not change today. When Ms. Di Gregorio commenced these proceedings, it is taken that she was aware, and I know personally that she was aware of the prejudice that various parties will experience. Ms. Di Gregorio threatened other people with proceedings herself for not discharging their obligations properly.
Anyway, you've still got your proceeding. You're still bringing the proceeding with Ms. Zhu and Mr. Ansell, and you're still seeking the same relief that you were seeking before?
No, so, Your Honor, the point that I was making about that example is that there's two issues. One is the prejudice, and the second thing is that we're saying that irrespective of whether or not it is Ms. Di Gregorio's true intention, and I say that that matter is also up for debate. What we're saying is that Ms. Di Gregorio is acting under duress because she has lost faith in this court's ability to do justice, and it is out of that intention that she has ultimately decided to extricate herself. And I say a big part of that decision was influenced by the costs order that Your Honor punished the plaintiffs with for seeking to enforce their statutory right.
Yes.
And I say statutory right.
I didn't release her from her obligation to make her share of that costs order.
Yes, but she doesn't want more such costs orders.
Yes.
So, Your Honor, rule.
No. Anyway, so.
No, if I may just.
But you understand that, do you? When I said no orders for costs, I didn't set aside the earlier costs order.
But that cost order did not deal with the expenses in this proceeding up until this point. That only dealt with the one appeal issue.
All right.
And even in that appeal issue.
All right. Anyway, I take your point. You say that by letting her out, to speak colloquially, without hearing from you first, it suggests that.
Not just me but all of the plaintiffs.
The three of you, yes. All right.
The three of us, including, yes.
And you would have said that I ought not let her out because she, having decided to commence the proceeding, she's obliged to continue on with it?
No, what we're saying is that first of all the court cannot do this as a matter of exercise of judicial power because it is required to hear everybody. So there's a point of principle there first. The second point of material prejudice is that there are costs incurred in these proceedings which the defendant will inevitably claim. Costs incurred until this point. Ms. Di Gregorio is, relevantly, a director of one of the entities, currently a director of one of the entities that is making complaints in this proceeding through me. This is Indistinct Pty Limited. It's raising complaints about relevant matters. Ms. Di Gregorio, on that account and on account of the fiduciary obligations that she has from her previous role as a director of People Shop Pty Limited, was required to consider the impact of her conduct on the plaintiffs. On their ability to, for instance, have access to her for the purposes of giving evidence and so on.
But she doesn't have to give evidence just because she's a plaintiff.
No, so because she's given an affidavit anyone can require to.
Yes.
Yes, but it's about availability. If she's already in court.
She doesn't have to turn up. If she doesn't turn up, she faces risks of orders being made against her or of proceeding failure.
That's right, so that's another incidental, but beyond that Ms. Di Gregorio also owes the plaintiffs money in relation to the preparation of the matter so far. The costs incurred by the plaintiffs in relation to this matter, and like I said
Well, if she owes you money, she owes you money, Mr. Kuksal.
Not me, I said the plaintiffs. I'm not saying she doesn't owe me money, but I'm saying the plaintiffs.
If she owes the other plaintiffs money, she owes the other plaintiffs money.
But Your Honor, that's the point. The point is that before releasing her, those are matters that we had a right to be heard about.
All right.
Either we were correct or we were not correct. But that's besides the point. We had a right to be heard. We don't have a right to get an order of a specific kind.
No.
We have a right to be heard, and I think it cannot be argued reasonably that the defendants would seek orders. There is extensive material being lodged in this proceeding. A lot of that material has been lodged by Ms. Di Gregorio. Just the consideration of that material properly will lead to considerable costs. Those costs, even if they were equally distributed between the plaintiffs. I mean, this is material that was lodged by Ms. Di Gregorio on behalf of the plaintiffs, and to the extent that it was for the benefit of all of the plaintiffs or some of the plaintiffs, those plaintiffs should have shared the burden of the expenses associated with the other party's consideration of that material. I also point out that different.
If you lose this case at the end of the day, you've got the right to argue that the costs you pay should be reduced, having regard to the fact that one of the people who might have been sharing that cost has been let out by the plaintiff.
Well, what Your Honor is saying is there is a way in which that harm can be mitigated.
Yes, potentially. I don't know if it's possible.
But that's really not the point. The point is that the court should not be the reason for the incurring of unfair liability. It sort of beats the purpose of being at court.
All right.
But, Your Honor, what I was saying is that.
So you say because I made the orders that were presented by consent between her and the fourth defendant this morning in your absence, the reasonable lay observer would think I won't bring an impartial mind to bear on hearing the matters.
We haven't started with the recusal application. We're talking about why the material is relevant to Your Honor's ability.
Okay, right.
To summarize it in a phrase, without seeing the material, Your Honor has no context of the nature of these proceedings.
Is it true though? I think you've acknowledged this, but I want to get it clear that there's nothing in that material that relates to behavior or misbehavior by me. This is material that's come to the prosecutors, to you as part of their disclosure obligations in criminal offenses brought by you. And I have no involvement in the investigation or presentation of those matters. That said, I note that I know very little about these magistrates.
Okay, I'd say that the material, if properly adduced, will give us a proper basis to inquire about whether the LSB has made private contact with this court.
With me?
Yes, with Your Honor.
What do you mean by private contact with me?
Okay, so for example, I can discuss this evidence because it's in the public forum. The LSB, after getting confidential privileged documents from Mr. McGregor, contacted a federal court judge privately in his chambers.
Yes.
To basically seek private determinations.
All right.
Outside of a hearing, and this is in evidence. It's in.
Yes, I'm interested by this.
Yes, Justice Weaverham is the name. He was sitting over a proceeding.
All right, so I can understand that if the VLSB had come to me and got private advice or orders or powers or something like that.
Or sought to influence you.
Yes.
We have a very strong suspicion that the suspicion.
And what basis do you have to thinking that they've tried improperly to influence me?
Because we know that they contacted every court in which the firm was involved in the proceeding at the relevant time. So they contacted Justice Weaverham. They have themselves acknowledged, and this is exhibited to my affidavit, which was exhibited to.
Again, so there's nothing to suggest, is there, that they've contacted me?
There is, I'm saying.
Well, what is it?
It's the fact that they've contacted every court.
Well, that means, there's no.
We were before Your Honor at the relevant period. This is the proceeding that ended in 3031. 20, so, SECI 202.
So I just want to get this right. The accusation is that the VLSB secretly had a discussion or conversation with me about how to.
They have exchanged emails.
Can you, hang on, Ms. Norton, I just want to get this bit. And when did this happen?
On the prothonotary, 2021.
I don't care about the prothonotary because it's me that we're dealing with. You're not going to say that there's no judge in the Supreme Court who can hear your case, is there?
No, I'm not saying that.
So it's got to be something that's come to or from me.
No, but in relation to a matter that was before Your Honor. This is the AGLSV 5 fish. What we're saying is that the proceeding number is SECI.
Yes, but just tell me clearly, I'm going to write it down, what you say the evidence is going to establish.
I'm not saying, I can't say that exactly because then I'm revealing essential attributes of the information.
No, in terms of me.
Yes, but, Your Honor, it'll be a breach of the Harmon undertaking if I'm very specific about what matters. What I can say is that the purpose for which we intend to use the evidence in relation to the recusal application or the purposes of that one, it will give us grounds to contextualize the harm that has been caused by the quote-unquote mistakes which Your Honor has dismissed as innocent made by VLSB.
Yes.
Secondly, it will present evidence that those decisions were definitively taken tactically.
Sorry, what decision?
For instance, not to file the summons before service.
Just make sure you're not standing over Ms. Norton again.
Yep, okay. So, for instance, the decision not to file the summons and before.
Yes, so what were the evidence? But the evidence you get in release of the Harmon undertaking will go to.
Yes, so what were the evidence? But the evidence you get in release of the Harmon undertaking will go to.
Shows that the VLSB plays dirty?
Plays dirty but has broken the law in playing dirty, specifically.
Okay, so I ask again, why does that mean that I can't hear the matter?
Your Honor, I might be able to short-circuit the position in relation.
No, you won't.
Well, let's just give her an opportunity, Mr. Kuksal.
Sure.
It's 12:05.
I'd begin by saying that, certainly, outrageous and scandalous allegations have been made.
Okay, I don't need to hear that.
Thank you. I have instructions to release the documents to the court so that Your Honor can see the documents.
I don't want to spend 3 days looking through documents trying to find something.
It's 16 pages of correspondence between a representative of the board and Victoria Police. I reviewed it last night.
Is this the material that Mr. Kuksal's talking about?
This, as I understand it, is the material.
This is one category of the material.
Ms. Norton, I think there's.
No, Your Honor, we would like that material to be produced.
No, wait, just hold on. I understand you are relying on quite voluminous material.
No.
How many pages?
Not even 20.
20. All right.
If we are given release.
Can I say, Mr. Kuksal, nothing you've said so far inclines me to give you a release from the Harmon undertaking because I just am not in a position to assess the rights or wrongs of that and the confidentiality otherwise of these documents and the impact it might have in the circumstances in which it was pertained.
But VLSB wants to introduce them into evidence.
Stop. Listen. If you want a release from the Harmon undertaking, it seems to me, the way I'm thinking about it now, is that something you've got to get from the court environment in which the documents were given?
No, it can be given. This court has authority.
Okay, I might have the power, in theory, to do it, but I'm very reluctant to do it.
But, Your Honor, I can.
I don't know what damage I'm going to be causing to someone else if I do that.
Okay, but, Your Honor,
Right, so that's the first point.
Okay.
So the second point.
May I rely on VLSB producing those documents to court? They've offered.
If the VLSB wants to produce some documents to me too.
To help us make this argument.
If they want to help us to make this argument, maybe we might do so, but
there is no reason why.
Take a seat for a second, Mr. Kuksal. I want to ask Ms. Norton.
Yes?
So what are you proposing? That I start looking at documents and…
Well, Your Honor, I was seeking…
With a view to Mr. Kuksal, you relying on those documents in support of his application to rely on other documents in support of his application to say I should recuse myself, which will presumably have to be heard in some weeks' time, when all these documents have been obtained.
I must say, I had only understood that the 16 pages of correspondence were the documents that he was seeking release from the Harmon undertaking, in respect of. If the release that is sought is broader than that, I can't assist. I should clarify, it's just been brought to my attention, that we would need Victoria Police's permission.
No, they wouldn't.
To provide those documents to the court. But I don't seek to make matters more complicated, Your Honor. I was seeking to provide those documents to Your Honor, if that was possible. They're relatively short, in relative short compass and, in my submission, they will make abundantly clear to Your Honor that the correspondence between the Board and Vicpol had absolutely nothing to do with Your Honor. Do not mention Your Honor's name, do not hint at the sorts of improper conduct that Mr. Kuksal is alleging.
Well, so far, Mr. Kuksal hasn't said that any of the documents he's seen have mentioned my name at all.
No.
He's been quite careful to say all they show is that the VLSB contacted the court.
Courts, various courts.
Courts. But you say that, Ms. Norton, but you've looked at, it seems, a small subsection of the sort of documents that Mr. Kuksal's relying on. Just going through the affidavit that is.
Which I haven't had an opportunity to review. And I should say, we still don't have the exhibits for that affidavit either.
There are no exhibits for that affidavit.
Sorry, for the previous affidavit.
Yesterday's affidavit is exhibiting about 6 or 7 other affidavits and Mr. Kuksal's estimated the exhibits go for 2,000 pages.
Over 2,000 pages.
Over 2,000 pages.
And several multimedia files.
And multimedia files, so.
We haven't been served.
Okay.
You have been served this morning.
Yes. So what are you saying, Ms. Norton? You want this whole thing adjourned for you to look through thousands of pages of exhibits to come back to a recusal application?
No, absolutely not, Your Honor. Absolutely not. I was seeking to assist the court. It appears that I haven't.
Well, you may have, but.
So I will resume my seat.
No, Your Honor, we urge the court to accept the documents that they've offered.
Well, they were offered and then it was clarified on instructions that the police.
No, they don't. The police have no objection. I can demonstrate that on transcript. There's a transcript of the proceeding where the police clarified to the court that they were not objecting, only the LSB was objecting.
So do you know what these 16 pages are that Ms. Norton's talking about?
Yes.
Okay.
There were the documents, as she's rightly pointed out.
Yes.
In respect of which, the original application for release from the Harmon undertaking was made before the disclosure of further documents yesterday.
Right. So these documents are documents that the VLSB has in its possession.
And we have in our possession.
Yes, but you got them because of the compulsory disclosure of circumstances?
No.
Well, if you…
So yesterday's documents were pursuant to the disclosure obligations.
Yes, okay.
These documents were pursuant to a subpoena.
All right, so these documents aren't caught by the Harmon undertaking?
They are, but the beneficiary of that undertaking is the LSB in that case.
Yes, so they can, subject to the other person with whom they're communicating's agreement, provide them without them being in breach of any undertakings because they're their own documents.
They're not, yes. Yes, that's right.
Yes. All right, so.
So the documents in their possession are not bound by any undertaking.
All right, So Ms. Norton has got the ability, subject to this issue about the other party to the communications.
No, they're not. So first,
Subject to that potential argument, she's got the ability to give it to you without me having to make any orders releasing anyone from any undertakings.
no, we have the documents. She's able to produce them to the court.
That's what I mean, yes.
Yes, to your honor.
And then if I looked at those, what would they show me?
What? Well, I can't talk specifically, but I can say for what purpose we would use them.
Yes.
I can't say what they will show.
And what purpose would you use them?
The purpose for which we would use them.
All right.
I can't accept that because of the nature of the undertaking. I can't specifically say, but we will not use those documents to say that the LSB communicated with your honor.
All right.
I can say that, and we will not use that. So, to clarify, when I said that it may show, the documents, the evidence that we will rely on may show that the LSB may have contacted this court, I did not mean it in the sense that your honor was compromised because of the material interest in relation to the LSB. All that I was trying to clarify was that we have evidence that shows the propensity of the LSB to contact every judge who was presiding over a proceeding in which the firm was active over a certain period of time in 2021.
Right.
Your honor happens to be one of the judges in relation to a proceeding between Avant-Garde Logistics Solutions, which is an entity that I own, and I was presenting the proceeding before your honor, V5 Fish Superannuation Pty Limited. Now, the nature of those communications is about inquiring with the judicial officer regarding whether or not they found any impropriety in the conduct of legal practitioners appearing in front of them, what, if any, are their thoughts about such perceived impropriety, so on and so forth. Justice Wheelahan was in particular given a draft affidavit that I had caused to be prepared. That was, in the LSB's view, to be used for his honor's recusal. So they took an affidavit from my lawyer, which they said I had instructed him to prepare, which was to be used, they said, for his honor's recusal, and gave it to him.
So they said that, yes. And were you copied into that communication?
No, his honor produced that to us.
Okay.
And then recused himself. So they produced this affidavit which they said was improperly prepared.
Yes. All right.
And then what they wanted was his honor to make sanctions against me in chambers privately.
Okay.
And his honor then.
So let's bring it back to me, right? Suppose you can show that they've done this. Suppose you show this.
And they've done this with every court proceeding in the magistrate's court and the county court by their own admission of an official from the...
They've done what? They've done what by their own admission?
An official from the LSB wrote to a director of that entity that I was referring to earlier, Avant-Garde Logistics Solutions, to inform them that they had written to the magistrate's court and the county court in relation to any proceeding in which that entity or related entities or I was involved.
Yes.
To ask the court to effect a permanent stay of the proceedings because we were not complying with Civil Procedure Act overarching obligations and the lawyers acting in the proceedings may have been improperly influenced to certify documents, and until the LSB gets to the bottom of it, all court proceedings must be halted. This is what the LSB official effectively admitted to us.
All right. Suppose that was so.
Every proceeding.
Okay, so does that mean that the fair-minded lay observer would think they can't? A judge isn't going to have an open mind when they come to hear the matter?
No, it means that we must be able. Now, what we think is that it wouldn't be the sort of communication that your honor may necessarily remember. We know that Her Honor Justice Forbes, when she was asked this question, she said she did not remember specifically. We were also before her, and Her Honor said she did not specifically remember, which, to my mind, raised the reasonable possibility that such correspondence may have taken place, in fact. So what I'm saying is that it may be that the court needs to check its records to confirm that the court may need to check its records to confirm whether or not that communication has, in fact, taken place and the extent to which it has taken place.
All right, Mr. Kuksal, I have decided that I'm not going to release you from the Harmon undertaking. I'll provide reasons in due course.
But I hadn't even finished all the reasons, Your Honor, why I wanted release from it.
No, yes, it's 12:15. You've had plenty of, well, how many more reasons? How long is it going to take you to finish your argument that I should release you from the Harmon undertaking?
5 minutes, if I'm not interrupted.
5 minutes. Okay, I promise not to interrupt you, Mr. Kuksal. It's 12:16. I promise not to interrupt you till at least 12:25.
Thank you. So, Your Honor, one aspect of the injustice that we will face if we are not released from the Harmon undertaking, as I pointed out, is the context of the extent of harm that we may face. The second aspect, as I pointed out, is that the documents that will be produced to the court will show that there is a very clear concerted effort on the part of the LSB to go about effecting improper plans to prejudice the litigation that I or related entities have in court. And we say that a reasonable and fair-minded judge, when they looked at that evidence, will necessarily draw inferences about conduct taking place in these proceedings and will be able to better appreciate their duties to prevent the LSB from taking advantage of those matters. For instance, the filing, the non-service of the summons, and I say that was a double-edged sword for us because, firstly, we were punished despite them tactically having lodged those summons, but, secondly, what the court found was that, and this was specifically pointed out in Your Honour's reasons, that we had formed the view that they had tactically done this and it was unreasonable for us to form that view, and instead we should have thought that this was an innocent mistake. And, because we thought that unreasonably and caused everybody to incur expenses, instead of the normal rule of costs, which is party-party, we were given a lump sum order or they were given a lump sum order against us, which is, as Colgate-Palmolive v. Cousins of the Federal Court, which I've cited before Your Honour before, clarifies, should be made only in circumstances where there was some impropriety by the party against whom the costs order is made or there are special circumstances that require that sort of order to be made in the interest of justice. So the deviation from the rule of party-party costs must only occur in those circumstances. Now, Your Honour found that we had acted improperly and Your Honour made inferences about our intention necessarily. It's clear from the reasons. I'm saying that Your Honour is not able to properly identify our intention because of Your Honour's ignorance of those documents, and that is not just a matter that affected the past decision which has already been taken. I'm saying that it will demonstrate to the court why we are so insistent and emphatic about all the steps that we are taking which, in a normal case, would not seem to be as relevant or as materially important. So we say that Your Honour is fundamentally unable to appreciate the context of these proceedings. And one central issue in dispute here, Your Honour, is that they're saying that our proceedings are scandalous and vexatious and so on. That's the ground that they've relied on to dismiss this proceeding today. Now, it is a clear common law principle that once the court is aware that there is, in fact, an issue, a controversy to be resolved, even if the originating motion is defective, the court cannot dismiss the matter. The court is required to litigate that issue, and there's authority for that. I will actually quickly cite that for the record just so we're.
Is this on the point you're wanting to address?
Yes, it is. Yep, because this is the point of injustice that we will face if we don't get to deduce that material. So the two authorities on which I rely are BANQUE Commercial COMMERCIALE SA Vehicle Holdings AKHIL Holdings Limited 1990 HCA 11 and Waterboard v Mustakis MOUSTAKAS 1988 HCA 12. So what we say is that we, firstly, assert that there is no basis for the allegation that the originating motion as it's drafted is scandalous, but if there were or if Your Honour was considering whether there is, the fact that Your Honour may be aware of evidence of a genuine claim that we have against him that is connected with the issues that are sought to be raised through the originating motion can permit the court to litigate the matter on the basis of that evidence rather than the originating motion. Pleadings are only a rule, a procedural rule. The matter is litigated on the basis of the evidence that's produced in the court, and the court can easily deviate from the pleadings and decide the matter on the evidence on the basis of, what is argued before the court. That is what those authorities stand for. Now, in that way, we would be significantly prejudiced if we are not released from the Harmon undertaking.
So the release from the Harmon undertaking, I thought you were bringing that application now for the purpose of your recusal application.
No, both. So what we're saying is that if.
And in the proceeding generally. Yes, I understand.
In the proceeding generally, and we're saying that if the first matter is that our claim against them is now fundamentally different on the account of the adduction of fresh evidence, so how can they seek a dismissal of the proceedings that we now want to redefine through the benefit of that evidence? We want to amend the originating motion. We note, first of all, we have a right to do that in these circumstances. It is a right, not a matter of discretion. There's fresh evidence. The court cannot decide whether or not to accept that application without considering the evidence. That's prima facie the case. The second matter is that we note that Your Honour had extended the same courtesy to the LSB in the related proceeding where they hadn't even produced, the draft originating motion that they wanted to draft, that they wanted to replace the current originating motion with, but Your Honour had just given them leave to file further material, and this would be gross disparity of conduct if we were not extended the same courtesy. Then, additionally, Your Honour, we also note that the LSB have themselves offered to produce that evidence, much of that evidence. We want 20 pages at the most. They are offering 16 of those 20 pages, so it would be specially unjust. They're not bound by the Harmon undertaking. They can simply produce. What they're saying they want is, as a matter of courtesy, to inform Victoria Police with whom they were communicating, and Victoria Police has confirmed to the board that they have no objection to the.
Yes. Ms. Norton, have you got instructions in relation to what Victoria Police's attitude is?
No, I can't update, Your Honor. I'm sorry.
Are you going to produce those pages or not?
Well, I'm now instructed that we're unable to do so without the agreement.
Because Your Honor, that was a trick that the LSB used to put on the transcript that they had nothing. This is gross misconduct, Your Honor.
Mr. Kuksal, enough with the outrage.
No, but this is gross misconduct. They offered to produce those documents to take a tactical point, only to then withdraw.
Yes, okay, yes.
Your Honor,
All right.
the.
So what more have you got to say on the Harmon undertaking?
That is another argument in favor of the release of the documents, because they have just pulled this trick, and for Your Honor to dismiss another trick of this sort, they made a representation to the court to say that they can release the documents. They're bound by that representation. There's an estoppel argument, an equitable estoppel argument that we can rely on. The representation was made specifically to undermine the arguments that I was making. It was said that if the evidence, they only made that representation knowing that the court will not accept those documents so they could preserve the point and not be prejudiced from the production of documents either.
All right.
What they said is that the documents that are produced will show that my allegations are scandalous.
I tell you, if the documents aren't produced, I'm going to not speculate as to what they say or don't say.
Your Honor is required to draw inferences. This is an inference.
All right.
It's an inference of consciousness of guilt. The principle was set out in Edwards versus R.
What's the consciousness of guilt? What's the guilt?
So, Your Honor, let me just read what the.
All right, Mr. Kuksal. So it's 12.30.
I was interrupted, Your Honor. Your Honor said I would not be interrupted before it was 25.
Mr. Kuksal, you had more than, it's now half past. You weren't interrupted until after 25 past.
It's 27 past and I was interrupted more than 2 minutes ago.
I don't know if you were. All right.
Well, Your Honor, I'm not.
I looked at my time.
It wasn't. The fact is that, well, Your Honor, in 2 minutes, Your Honor also asked Ms. It's been more than 2 minutes.
Okay.
Now, Your Honor, if I may just adduce the principle of consciousness of guilt specifically.
No. Tell me what the guilt is. You say, that you say that the VLSB knows that it's done all sorts of wrong things and.
So, Your Honor, if I may just read 2 paragraphs from an authority about this.
All right.
Because they specifically address the issue.
Yes.
This is from Zoneff ZONEFF v. the Queen. Citation is 2000 HCA 28 paragraph 60 and 61. Probative lies, on the other hand, are those which naturally indicate guilt, a hard test to satisfy. This is a hard test precisely because it is rare that a lie about a particular matter will be so crucial as, of itself, if proved, to establish directly guilt beyond reasonable doubt of a criminal offense. It could happen if, for example, the lie related to an object indisputably linked to the offense. Then so what the court was saying there is that the manner in which the court can deduce that there may be a consciousness of guilt is if a party in relation to a matter that is central to the offending makes assertions or allegations which seek to offer exculpatory evidence or achieve an exculpatory effect about their involvement in that offense, those assertions turn out to be false. They were made in circumstances that they could not have reasonably made them responsibly. And they were made, effectively, to prevent the determination of their guilt. So they know that evidence is problematic for them. They're conscious of that guilt. What they tried to do was effectively impede the discovery of that evidence because in saying that the evidence will not show anything, they have prejudiced the court from agreeing to my application, acceding to my application for the discovery, but they never actually intended to produce those documents to the court themselves. So when their bluff was caught, they basically said, there's another reason of nicety to Victoria Police, who's not objection to the production of documents anyway. So that's the guilt. The guilt is about the matters that will be disclosed by the evidence.
If I'm against you on your application for relief from the Harmon undertaking, what happens to the application for recusal? Is there any argument?
That will be another ground in support of that application.
Okay.
Because, in these circumstances, there is no basis. They have offered.
Mr. Kuksal, wait a minute. You've made 2 previous applications for recusal.
You've made
2 previous.
Not in these proceedings.
No, but recently, seeking recusal.
But can the court endorse those reasons in this?
Mr. Kuksal, please don't interrupt me.
Yes.
And each of those was really that I recuse myself from all matters concerning you, as I understood it. You've come along on this application, saying that there's additional material you got yesterday that you want to rely on.
Not just yesterday, but previously, for which we have foreshadowed. We had made an application.
I thought it was the documents that you got just yesterday.
Those, and the 16 pages that the LSB's offering to produce.
Okay, all right. Nevertheless, you've come along saying there's some documents that you want to rely on.
We have filed summons for that, Your Honor.
Okay,
This is a matter that's before the court to be determined.
Okay, if I don't grant you leave, if I don't grant relief from the Harmon undertaking.
Release, yes.
In whatever form that is made, what do you have to say about the recusal application?
So if,
Does that stand or fall? What I'm saying is if I reject your application for relief from the Harmon undertaking, does it?
release from the Harmon undertaking.
Release, sorry, does it follow that I would have to reject your recusal application?
No.
All right, so,
That would be another basis for the recusal application because first of all,
because it would be wrong.
it would be wrong, but also how can the court decide this matter without critical evidence in relation to this matter?
All right, Mr. Kuksal, I don't propose to release you from the Harmon undertaking.
Can the court make an order that the LSB produces the documents?
No, I'm not going to make any orders. I'm going to dismiss your application for release from the Harmon undertaking. Now, will you proceed with your recusal application?
May I have reasons?
In due course.
Okay, but Your Honor realizes that we want to amend the originating motion on the basis of those documents.
I'm dealing with the recusal application now. What do you have to say in support of your recusal application?
Yes, so okay. So the recusal application, then, Your Honor, firstly, is based on the, I say, firstly. This is not how it was structured originally, but because this matter is current, I might as well get it out of the way for efficiency's sake. We think that it was unreasonable for Your Honor to deny the release from the Harmon undertaking and to simultaneously not require the LSB who had offered in open court to produce the documents and is now saying that.
Yes, all right, so you say that was a wrong, unfair decision of mine?
It's wrong because it's unjust, but also because, simultaneously, the court cannot then expect to move on with the three matters from our previous summons and their application to dismiss our case.
Yes, all right, so you say that was a wrong, unfair decision of mine?
No, I'm saying Your Honor knew about that and, despite that, Your Honor made the.
Knew about what?
Your Honor, the items on the agenda, Your Honor is aware of them.
Yes.
They include the LSB's application.
Yes.
That our case against them is frivolous.
Yes.
The evidence that we have fundamentally goes to ensuring that that is not the case and that is not my assertion.
When you say the evidence you have, you mean the evidence that you can't produce because of the Harmon undertaking?
That's right, and that's not my opinion.
Yes, all right.
That's a judicial determination.
All right.
Let me just state this, those documents were subpoenaed off the informant. The informant did not object to their production. The LSB then raised a public interest immunity objection. The magistrate determined in that case that those documents were relevant because they were capable of showing unlawful conspiracy between Victoria Police and the LSB to prejudice my criminal proceeding or my rights in relation to the criminal proceeding. That is the only proceeding. That was what their lawyer told Justice Ginnane. Their lawyer, and I have the transcript in evidence. I can, rely on that. And this was actually the excerpt of that, the excerpt containing that submission from their lawyer to Justice Ginnane was sent to the court and the other parties on the 30th of November when we were seeking release from the Harmon undertaking or foreshadowing that application which was brought on summons yesterday. So their lawyer, Mr. Kelly, has made a submission to Justice Ginnane that Magistrate Williams found that the documents which were subpoenaed are capable of demonstrating a conspiracy, unlawful conspiracy such that Victoria Police was either the Legal Services Board was either influencing Victoria Police unlawfully to commence or maintain the proceedings against me, and therefore, His Honour found that those documents should be released to me over the public interest immunity objection, which His Honour found was particularly weak. So Your Honour has a transcript of a public proceeding before Justice Ginnane where their counsel, Mr. Kelly, made that submission.
Where do I have that?
So the email that was sent.
No. Is it in evidence before M?
Yes.
Which?
It's at the email is exhibited to.
To which affidavit?
The 4th of December affidavit.
And what exhibit?
And also the transcript.
So the transcript before Mr. What exhibit is it?
Let me just bring up the affidavit, Your Honour.
And once you find the exhibit, tell me the exhibit and the page, the exhibit number and the page number of the transcript you want me to read.
Okay.
The date and the page number.
Okay, so it's.
So I think I'd thought that the documents you're talking about had come out recently. You say some came out recently, but some came.
No, so documents came out recently, but
meaning in the last day or so.
The discussions about whether or not they should be released in relation to which no Harmon undertaking applies.
Yes, all right.
And by the way, so for instance, these documents can be discussed in the proceeding before justice.
Anyway, you're going to give me.
It's PA 23.
You're going to give me a.
PA 23.
And what page number of the transcript?
So let me just.
And the date?
Yes,
How long is Pennsylvania 23? Have you got a copy there? How many pages?
It's quite voluminous, but.
Well, how many pages?
I'm trying to bring it up, Your Honor. So PA 23 comprises of several transcripts, and the transcript on which we rely is the transcript from the 10th of November.
Which year?
This year.
Yes.
And the relevant part of the transcript may be found on page. It starts from P27, I'm told. I'm just bringing it up myself, so if I could just.
No, give me the page number.
Yes, it starts from P27 of that transcript.
What page number do you want me to look at? Page 27?
Starting from P27, Mr. Kelly's part, and he continues until P32, I'm told.
27 to 32, okay.
Is where he says, and if Your Honor reads that part, then Your Honor will have an adequate understanding.
Right.
If I may just read what he said verbatim from the transcript.
How long are you going to be in making the balance of your application? I have to rise at 1 o'clock, I can't sit through into lunch. I can come back this afternoon if need be.
Let's do that. So let's.
How long are you going to be in your recusal application?
I say I'll need an hour if I'm not excessively interrupted, but it depends on how many questions that Your Honor has.
How can you take an hour, when this is? Are you really only going to be? I mean, the recusal application has been made twice.
Yes.
What is different this time?
All the matters are matters that have not been raised before in the previous applications, but I will request that Your Honor formally endorse the reasons for the matters that have already been raised in this proceeding, so it applies to this proceeding as well and I don't have to raise those issues. Because in order to raise an appeal in this proceeding we will be prejudiced both ways, Your Honor. To raise an appeal in this proceeding we should have raised those matters with the court in this proceeding.
Whatever I decide, then I will refer to my earlier decision.
Okay.
Is that what you mean?
No, but I wouldn't have raised those issues. So if Your Honor gives, the issues are for reasons indistinct. If Your Honor makes an order to the effect that we can rely on having raised those issues and the determination of those issues in those proceeding, then we don't have to raise those issues again her.
Would it not be an abuse of process to just rely on the exact same issues for a second claim?
No, but we're not. We don't want to rely on those issues, but what we're saying is in order for us to raise the appeal, if the court can simply say that we can take those issues to have been decided in this proceeding as they were decided in the other proceedings.
Yes, okay, I understand what you mean.
Then we don't need to raise those issues.
Well,
and we raise only the third passage.
I'll think about that. Yes, so you say you want to present the same arguments as you did on the last occasion.
No, I'm saying I don't want.
But as a matter of form you want to be treated as having presented the same arguments.
Yes.
On the previous occasion.
As a matter of technicality without taking the court's time. And then we only want to raise new issues which were not raised, and that would take an hour.
Okay, and the new issues, can you enumerate them for me now in summary time?
Yep.
Rather than just have an hour.
Yeah.
I mean,
I can do that.
Rather than have an hour of stream of consciousness type from you, enumerate.
No, these are all.
Enumerate the points for me now.
Yep. So, firstly, the main contention of the application is that we say that Your Honor is incapable of deciding this matter as if Your Honor was coming to the matter with an open mind.
Yes.
And that about the elements that we seek determination in respect of, I've been prejudged by His Honor.
But this is new points you're dealing with.
Yes.
So what's the new point?
When I say new point, it's points that were not raised before. Not new evidence or points that have.
These are points that could have been raised on the last occasion but weren't.
They were not relevant to that proceeding.
Mr. Kuksal, the application you made.
Yeah.
Was that recuse myself from all proceedings concerning you?
That application was made in the proceeding only though.
Do you agree that the the relief you sought was that I recuse myself from all proceedings concerning you?
We had intended to make separate applications in these proceedings.
You agree that the relief you sought on the last occasion was that I recuse myself from all proceedings concerning you?
It's a nuanced matter, Your Honor. That is what I had wanted.
Yes, and that's what you asked for.
But I didn't think that Your Honor could make orders in that proceeding.
Okay, so you wanted me to make orders that I recuse myself from all proceedings.
From hearing any matter involving me.
Whilst believing that even if I did so, it wouldn't take effect in other proceedings. So.
No, what I had thought.
If I make the order, great. If I didn't make the order, you could renew it in another proceeding.
No, Your Honor. What I had thought was that in that proceeding I could raise only some matters related to the other proceeding which went to essentially fundamentally incompatibility of Your Honor's temperament with Your Honor's duty and not about the specific prejudgment related issues in other matters because that relate specifically to those matters. Now I had thought that based on the issues that I was raising about the temperament, my submissions will be accepted, and if Your Honor acceded to that application, the effect of it will be that Your Honor would ultimately have to recuse himself from the other proceedings.
Okay.
But what I had envisaged was that Your Honor would make orders then in other proceedings without formally requiring
All right.
of application by, to the use of a process such as the one that I highlighted, that the court deems it that we have made the same submissions.
All right. How many points are you going to raise this afternoon? I asked you to enumerate them.
Yes, and I was trying to.
Yes, so how?
So the first one is the point about the prejudgment related issues.
Prejudgment.
Yes,
Prejudgment of?
prejudgment of our application against VLSB and the application against.
Of the entire proceeding?
Not every point of the proceeding but the main elements of the proceeding.
Prejudgment of the proceeding. That is, I'm prejudging that the VLSB hadn't acted for an improper purpose.
Yes,
I prejudged that?
yes,
In your argument. All right.
and you prejudged that we don't have a case against them.
The second point?
The second point is that Your Honor, in our view, has been misrepresentative in this is a new evidence-related matter which had gone to previous things.
Yes, just tell me. Misrepresent?
Misrepresentative in the manner in which Your Honor has published reasons. Misrepresentative of the actual facts in a way that shows that Your Honor has, this is a reasonable apprehension argument, I'm not saying actually.
Yes, I just want the.
Yep, just to clarify, I'm not making an allegation against Your Honor. I'm saying that there's a reasonable apprehension.
I understand, Mr. Kuksal.
Okay, so, but it's also for my sake, not only for Your Honor's sake, that I'm clarifying that.
Okay.
So the second point, or the last one that I was referring to, was that the reasonable apprehension is that Your Honor may have prejudged the matter and is therefore structuring the factual representations about the proceedings in the reasons so as to justify the prejudgment.
Yes.
That Your Honor has committed himself to.
Yes.
Then the.
Third point.
Yes, the.
That's the second.
Yeah, this was about specifically the factual elements of the matter. The third point is that, again, this is a point about misleading, the misleading effect of the reasons. In Your Honor's reasons, and this includes specially the last reasons, Your Honor has specifically not addressed the authorities that went against Your Honor.
Okay.
And has just, in a very general way dismissed assertions made by us.
Yes.
And we say that that was improper. And even besides that, Your Honor has not even listed the most problematic of the assertions. So Your Honor did not raise the main authorities and the main legal arguments in respect of which we say that Your Honor has committed an error of law or a jurisdictional error. And even the ones that Your Honor listed, Your Honor did not address the specific authorities that we had cited.
Yes.
That's the third. The fourth matter is that Your Honor has specifically addressed issues about which we were not on notice, and therefore we did not feel the need to respond.
What were they?
Then, Your Honor, we're going into the substance of the application. If I.
Well, no, list them. I'm asking you to enumerate the.
But that's a sub-point, not a main point, so.
Yes, not on notice of issues. Okay.
We weren't on notice of issues.
And how many issues do you say there were that you weren't on notice on that I dealt with?
I'd say broadly there would be around 5 or 6 categories of those issues across the proceedings.
Yes.
And this is, again, much of this is new, which wouldn't have been brought by the application.
Yes. 5.
Yeah, so then.
The next point, the fifth point.
Yeah, the next point is disparity in conduct. Again, this is a new issue. Your Honor has treated us differently from the manner in which Your Honor has treated other parties appearing before Your Honor.
Yes.
Specifically in relation to leaves for applications and so on.
Yes.
Then we say, so this is the sixth point, I understand, or the fifth one.
We're up to 6 now.
5, okay.
That was the fifth point, that.
Yeah, so the sixth point, then, is that Your Honor has also misrepresented, or there's a reasonable apprehension, I should say, that there may be a misrepresentation in relation to the cause of the complaint or the effect of prejudice that we've suffered. An example of that is when Your Honor said that, because the court instructed me to correspond with Ms. Anaz in a manner that every court would have required, but in this context it led to some difficulty, I asserted that there was a temperamental incompatibility.
Yes.
That is not what I had said. What I had said was Your Honor did that knowing that I could get into trouble. On the 18th of August, Your Honor noted in court, it's in the transcript, that if I continue to communicate with Ms. Anaz, then I could get charged.
Okay.
I'm paraphrasing, obviously, but that Your Honor knew that I was being exposed to risk.
All right. You weren't charged. Have you been charged?
Your Honor, Ms. Anaz has just given a statement saying that I'm on the cusp of getting charged.
Okay.
In a magistrate's.
So it's still a risk, as far as you're concerned.
Well, I feel that if there's no, it's a pre-decided matter because Emza Naz, who I believe is now working for the Victoria Police.
Okay, anyway, let's move on. That's the 6th point relating to my communication issue.
Yeah, that.
Yes.
Either Your Honor did not actually understand the.
Okay, 7th.
I'm just going to refer to the document that I have.
When you've finished this list, I'm going to hear from Ms. Norton, who's been keen to get on her feet to say something, then I'm going to adjourn the matter until 2.30. I'm going to give you an hour, effectively, uninterrupted, Mr. Kuksal.
Yeah, so the 7th matter is that Your Honor has essentially created, there is a reasonable apprehension that Your Honor may have created impediments to the presentation of our case which prevent us from properly litigating our case.
Yes.
And deny us our right to equal treatment before the law and our right to being treated equally in proceedings before the law. So those are Charter of Human Rights and Responsibilities related arguments. And then we say that there's also further jurisdictional error beyond the previous occasions about the adduction of evidence. And this is very specific, not just a continuation of previous issue. On the 28th of November it was pointed out to the court that my affidavit of the 17th of August, which the court had rejected previously, and in the reasons it stated that it was rejected because it was too long and that it had lacked an index for listing what page a specific exhibit starts from and ends. I note that each document was individually exhibited and not exhibited just as a bundle, but, Your Honor, it is my submission that a reasonable judge looking at the evidence and its probative value and what was alleged on that evidence, if they applied the law, as is set out in the Evidence Act, which is a code in relation to Chapter 3 on the admissibility of evidence-related issues, they could not have decided to reject the evidence. Now, this is specific because previously we've complained that Your Honor has placed arbitrary limits.
Yes.
This was not arbitrary. Your Honor had considered the affidavit.
Well, you'll have to take me to the paragraph in my reasons where I deal with that.
Yeah, I will do that when I raise the recusal application.
Yes, all right.
But what Your Honor said was basically that Your Honor had considered the material and then specifically rejected its adduction knowing what it was capable of doing for us.
All right.
So that goes toward fundamentally the fact that Your Honor's not wearing a gauntlet, Your Honor's wearing a robe for the other side.
Not impartial.
Yeah, Your Honor is assisting the other side.
All right. That's 8 points. How many more do you have? It can't be that.
Those are the points.
Those are the points. All right, Ms. Norton, you have been wanting to say something.
Well, Your Honours anticipated what I was wanting to say, which was really that there be a time limit imposed on the remainder of the recusal application.
No, that's all right. Yes.
So thank you, Your Honour, for that.
What I'm going to do is I'm going to stand the matter down now. I'm going to stand it down until 2.30. And, Mr. Kuksal, I'm going to give you, as best I can. I might have to bite my tongue a bit because I know that I ask questions in a way that's not always conducive to things moving quickly. I'm going to give you an hour to present your
hour plus the time for questions, Your Honor. That should be.
Mr. Kuksal, don't tell me what there should and shouldn't be. You were ordered to make a written submission of no more than 10 pages on these matters. You haven't done it on your application for recusal.
Not on these matters, Your Honor.
Or maybe you weren't ordered, maybe you were offered.
Not just offered, but these are new issues.
Yes, all right. What I'm saying, I will give you an hour. I will do my level best not to interrupt in a way that adds to that time frame. If Ms. Zhu or Mr. Ansell have got anything to add, I'll be surprised if they do, but they can have a couple of minutes each. I'll hear from Ms. Norton and then I think I'll have to reserve.
But one thing I'd like to clarify is that the denial of the court in relation to the Harmon undertaking application is in respect of both the recusal application and the originating motion and the.
At the moment, I had in mind the recusal application.
So will the court.
I don't know. I have to think about that. I understood the application that was being brought was in the context from the material that you wanted a release from the Harmon undertaking so that you could prosecute the recusal application.
No, Your Honor, the reason why it was brought then was because we.
Be that as it may, Mr. Kuksal, I am of the view you shouldn't be coming to me to get a release from the Harmon undertaking without the other relevant parties from the magistrate's court being here and without you haven't tried to get a release from the Harmon undertaking from the court in the context of which the Harmon undertaking is imposed.
But, Your Honor, then you'd have to adjourn the matter.
No. Well, you might say that, but I've decided, based on the matters that were put, that I wasn't going to release you from the Harmon undertaking. That of course is something that might be right, might be wrong. All those matters might have to be dealt with again, might not. But, for the purpose of your recusal application, at least you have to work on the basis that I haven't released you from the Harmon undertaking.
Okay, I will, Your Honor, send an email with just the transcript of the 10th of November.
I'm not interested in receiving any emails from.
But, Your Honor, you must read 27 to 32 pages.
Yes,
The submission of their counsel.
Mr. Kuksal, I'm going to adjourn the matter until 2.30 and I'm going to hear your application for recusal, further submissions in relation to that, for another hour. And then, unless I've got a clear view, I'm likely to reserve on the matter and come back as soon as we can.
But then the next matter cannot be heard until Your Honor.
Correct. That is the reality. So when the other applications get heard, we'll have to work out.
Okay, will the court? I'm just trying to speed up matters by providing the material so I don't have to read it out in court. May I just present the…
Mr. Kuksal, the time for you to put written material in was weeks ago.
We have done that previously.
I do not want, you've got an hour to present oral argument and then I'm going to, that's the end of it. I'm not going to then receive, last time you sought leave to put in 10 pages of authorities.
No, I'm going to do it during the lunch time, not afterward.
Yes, well, we'll see, but last time, I remind you, you sought leave to put in no more than 10 pages of authorities. Weeks went by, then you put in a very lengthy sort of document, and then you put in a document like that. And that caused delays. I want to have this application, the material in support of the application is going to be over this afternoon, is my plan.
Okay.
And I'm going to have to think about what I do about it.
Thank you, Your Honor.
2.30. Mr. Kuksal.
Good afternoon. Okay, so Your Honor, just to clarify matters, I have an hour of what should be uninterrupted time to rely on the evidence that we filed and to make submissions.
You have an hour to make your recusal application.
And I will make it.
To the extent that you haven't already done so.
Okay, and would Your Honor take offend that the matters that were raised in other proceedings in relation to recusal, which may be relevant to this one, I should take as having them raised and rejected, as per Your Honor's reasons delivered recently?
I don't quite understand what you mean by that.
So, Your Honor, as for the discussion that we had before break, the grounds for recusal that were raised in the proceeding ending in 03994 on the 3rd of November.
Yes.
Which were previously rejected, and then the grounds for recusal that were raised on the 28th of November in the same proceeding, 3994, I can take that those grounds, if raised again today, would be rejected for the same reason that they were rejected on, pursuant to Your Honor's reasons, published on the 28th of November, and then further reasons given orally at that particular hearing.
I think so. If you want me, I can't see why, if you presented the same arguments, I wouldn't reach the same conclusion. Do you want to say that you are taken to have presented those arguments?
In this proceeding, yes.
All right.
I'm taken that Your Honor has rejected those as well for the same reasons that Your Honor published.
All right.
Thank you, Your Honor. Now, Your Honor.
This is for, as you were saying.
The further.
To get the appeal, so everything's together in one place for an appeal, if need be.
That's right.
All right. So I'll just take it that the reasons I gave on the last occasion would apply equally with the arguments with which they dealt, brought, presented by you now.
Yes.
Yes.
Thank you. Now, Your Honor, we identified 8 different grounds before the break and I wish to quickly go through them. So I also clarify that I have numbered the exhibits with an imprint on them to the right bottom end of the document, and I've circulated a revised link to download the exhibits with those imprints. So it'll be easy to refer during the proceeding now. So I'm just going to, when I rely on the exhibits, I can then refer to that particular.
If you can rely on a lengthy exhibit, you have to identify the particular page.
The page numbers, yes. Yes, okay.
And they're not pp 3 to 700.
No, I've never done that, Your Honor.
No, all right.
No, okay. So firstly, I rely on the affidavit of Ms. Du Gregorio. That was affirmed on the 21st of December. In Your Honor's reasons.
What date?
The 21st of December 2012. 2022, sorry. The 21st of December 2022.
Yes.
In this proceeding, and Your Honor has referred to that particular affidavit in your reasons that were published on the 23rd of August, and this is the 495 judgment, so 2023495, and Your Honor refers to it.
So you're relying on that affidavit?
Yes.
Which has been filed in what proceeding?
This proceeding, 04028.
This proceeding, okay, yes.
And Your Honor referred to it in paragraph 18 of the reasons that were published on the 23rd of August. The citation ends in 495. It's referred to in paragraph 18, so paragraph E. Now, the one may be inadvertent, indistinct, there is that it had some videos accompanying it which were also lodged with the court. But the links to them were also embedded in the body of the affidavit. Now, I wish to play a couple of those, or a few of those videos. They're very short videos, a minute or two long, and it's the evidence that I rely on in relation to the recusal application. So how would I go about playing them, Your Honor?
First of all, tell me what they are.
So these videos are relied upon in relation to the first ground, which is that Your Honour has prejudged the LSB's application against us for dismissal of the proceeding and our claims that the LSB still have abused their authority. And the videos demonstrate Mr. Rapke specifically inviting Channel 9 into the office or Ms. Lulu Zuchek first checking with Mr. Rapke whether Channel 9 would be let in if they enter the premises, telling them that we have proceedings against the specific reporter for defamation. Then they show Mr. Rapke and others from the LSB watching as the Channel 9 cameraman is literally recording the contents of the file.
Yes.
And one of the LSB representative, Mr. Gordon Hooper, directs the Channel 9 cameraman to a room where Ms. Kylie Bond, Mr. Rapke's associate, has opened up a binder for them to record further evidence.
Right, so it's video of what's happening in the rooms.
Yes, which Your Honour referred.
So where did I refer to it?
Paragraph 2 of Your Honour's reasons, published on the 23rd of August. So I'll refer to those reasons as the 495 reasons from now on.
Sorry. Let me just get them. In which matter?
The citation is 49, the same reasons I was referring to in this matter.
Which proceeding?
This proceeding, the 23rd of August, paragraph 2, citation is 2023 VSC 495.
Yes.
I read those. I read the relevant background before lunch.
495? Yes. Paragraph 2. Yes.
So these videos that Your Honour referred to are what I want to quickly play.
But you say I referred to Mr. Gregorio's affidavit, do you?
Yes, on paragraph 18.
18, sorry.
So paragraph E.
Yes, I refer, yes.
So these videos are from that affidavit?
Yes.
So how do I play them, Your Honour?
Well, do you have them?
Yes, on my.
Have you made any arrangements with the court to say you want to play videos in court?
Ms. Sue had raised it with the court previously.
And what was the response?
Yeah, you will let us play the videos.
All right, well, I don't know how to go about playing it. I'll stand. If you want to show the videos now, I will stand the matter down for 5 minutes. Whilst you do that, make that arrangement.
With your associate?
Yes.
Thank you.
If that can be done, this is part of your hour. Stand the matter down temporarily. Mr. Kuksal, you want to play some videos?
Yes, Your Honour. So I'll start with number 64. It's only 19 seconds long.
Who's in charge? I'm sorry, who's in charge? The building. Who's in charge? So you guys invited Channel 9?
I've got control of the premise to the all authorised.
Sure.
Thank you, Mr. Security Guard.
All right.
The next one is 52.
Various files this practice for clients?
I do not have to answer your questions.
You do. Show me where the files are, please.
If you're taking stuff, I'll take a video and then we'll just get the receipt.
I can take anything I want. All I have to do is give you a receipt and return it in due course. So you can either do this the hard way or the easy way. Okay?
Okay, I am not
you're
authorized.
refusing, are you? Why don't you
Well,
stay,
no, sorry.
why don't you stay in this room?
No,
and
I'm just gonna video
We'll search the
whatever.
You've got no power to video me. You can stop
Why?
now. You can stop now.
I'm not gonna video you, okay? I'm just gonna video whoever is taking the document to make a record of whatever
You
is
don't
being
need to do
taken.
that.
Why?
I'm asking you to stop videoing me.
I'm not even videoing you.
What are the computer passwords? I'm giving you one last chance.
I do not
Otherwise,
know.
I'll do it another way, which I readily
Just
can.
ring Mr. Ansell, I think. That might be the best way. He's the legal director.
Ring him and get him to come straight down. You're being very foolish here.
Well, if you're the manager, why don't you ring him?
Because we will.
Then do it.
We will.
Okay.
Mm-hmm.
It's okay. Can you please? I'm gonna video whatever you're
No,
taking.
you're not. You're going to stop.
She just
videoing.
said that.
No, you doesn't have to video. We'll just get access to all the computers. Andrew, can you start with anyone here? And if they're not going to get any assistance by this employee, I'm directing you to now access the computers as best you can from here, otherwise we'll take them away. And then we'll find out how this practice operates.
Can you make sure that you take some care of them?
I'll do whatever I want, okay?
Whatever you want,
Yes.
as in you will
I
damage
will
them?
do whatever I'll do whatever I need to properly execute my duties as manager.
Okay.
All right?
All right.
Are these videos taken by Ms. Zhu?
Yes.
Yes, all right.
Number 8. Number 8. Ms. Zhu and Ms. Di Gregorio were both present and they were both coordinating on the number 8. Your Honor, this is critical.
So he's still working on this anyway, right? So that's Has you given kicked out? That's right.
So, to clarify there, the Channel 9 cameraman was recording contents from the binder of the ONI file which had been left open at the reception. It wasn't. The receipt that Mr. Rapke has sent us about where the files were when they were collected shows that the file was in my office. But after Mr. Rapke had kicked Ms. Zhu out, they had then taken the binder from my office, opened it up at the reception desk. For now, the list of where files were is exhibited to Ms. Di Gregorio's affidavit. It wasn't said that that particular file was taken from atop the reception. So it had been opened up and kept at the reception. The cameraman of Channel 9 was recording the contents of the file. He then questioned Ms. Zhu about, Mr. Kakiara then questioned Ms. Zhu about information that was in that binder, specifically that we were going to sue Victoria Police in relation to the ONI proceeding. He asked the question of Ms. Di Gregorio as well. And in that video, what can be seen is Mr. Hooper, who was the investigator appointed by the LSB. By the way, he had no business being on the premises. He was there with Mr. Howard Bowles, the person who has appointed both Mr. Hooper and Mr. Rapke. So Mr. Hooper watches the cameraman recording the content and then lets him know that the other files are set up for him in Ms. Di Gregorio's office. The cameraman then goes to Ms. Di Gregorio's office to record other files that were, again, placed in an open state on her desk by Ms. Kylie Bond. Another video captures her doing that. The next one is 12.
I'm a bit concerned you might be wasting your time, in the sense that I don't immediately see why these videos mean I should recuse myself.
Yep, Your Honor, if I could just get 2 minutes.
You spend your time as you wish, but
Can you writing leave documents to me and sending me the papers now?
Sorry.
You might like to have one of those as a memento. You're a director. That's interesting, isn't it? For someone who's
Why
so
don't
involved
you
with the
read
business.
documents?
Another director, and you're a director too. That's all right. Kylie, could you just escort her off the premises, please? We'll give her 3 minutes.
Just let her collect this. I'll tell you who I am. So my name's Tim Gear and I'm a detective sergeant with Victoria Police. So our role here today is just to ensure that there's no breach of the peace occurs. All right. You've been directed though by the manager now of the law firm to leave the premises. So if you could just pick up whatever personal items you have, and then we'll escort you off the property. Okay.
Well, what if I need to come back and get more stuff?
You can notify the manager and make an appointment with the manager. Will
I don't have his contact details.
Oh, we'll give them to you. That's fine. What's your name, ma'am?
Lulu.
Lulu. Do you just want to collect your personal
Lulu,
property?
before you go, a couple of questions. Thanks, Tim. Appreciate your help. A couple of questions. Are you obliged to answer them?
I'm not obliged to answer you any
You're
question.
obliged to provide information to me as manager. There are numerous computers I can see within the office. Before you go, I would like the passwords and entry codes for all of the computers.
I don't have that.
You do not know how to operate the computers in this office.
I do not have the passcode.
You don't have the passwords.
No.
Who does have the passwords?
I don't have the authority to tell you. If you want to exercise your power, you can do that, but I'm not an authorised person to tell you
Just so you
that.
understand, under the legislation, obstructing the manager is an offence. Do you understand that?
If I don't know, I can't tell him.
I'm just letting you know. Do you understand that by obstructing the manager, that's an offence? Do you understand that?
How did I obstruct him?
He's just asked you for information.
Yeah, I
he's
said I don't
entitled
know. No, I do not know.
to. You don't know?
No.
What do you do here, Lulu? How did you get in here?
I'm sorry,
Well, you don't have to answer
It's,
those
yeah,
questions.
yes,
Pardon me.
no.
All right. Have you got all your belongings?
Sorry, what's your name?
I don't say mine. Have you got all your belongings?
Well,
Just before you go, I would
Sorry.
like to sit down and talk with you. Why don't you come in here? Kylie, can you come in here too? And Andrew?
Oh, yeah.
Well, yeah, yeah.
Sit down.
I'm sorry, you don't ask me to sit down or stand. I'm a human, right? I can sit or I can
You
stand.
sit down, because I'm talking to you and I'm directing you what to do.
Lulu, I'm Kylie.
Kylie, sorry, can you tell me if this man asking me to sit down, do I have to sit down? Or can I ask the police officer?
You can ask them if you like. I'm the manager asking you to provide me with information.
Okay, yeah, you pointing that chair asking me to sit down is not
Just
something
listen.
I have to do.
Listen for one moment, okay? My name's Howard Rapke, and I'm a partner of Holden Redlick. I hold a practicing certificate as a principal, authorising the receipt of trust money as required under legal. My name's Howard Rapke, and I'm a partner of Holden Redlick. I hold a practicing certificate as a principal, authorising the receipt of trust money as required under legal profession uniform law, which I'll refer to the purpose of this notice as the Act. From today, the Board resolved to appoint me to manage the law practice people shop, trading as erudite law, pursuant to the Act. I confirm at the time of entering the premises today, you were provided with a copy of my notice of appointment and instrument of appointment. Have you got those, Kylie?
I don't have any.
Okay. Take those, please.
Well, I'm not authorized to take it. Why do you have to?
You were served with them.
Oh, you can serve me, I'm not.
Also, I show you my driver's licence,
No, you did not.
He's going to.
which includes my photograph and my
Well, that's
signature.
concluded. Sorry,
Coming,
there's a
John.
red folder that you put into your bag.
That's my, okay.
I want to have a look at that
The
first
manager is
before we go
entitled
through
to open that up and see what's in it.
That's my licence with my signature and my photograph.
Sorry, that's mine.
Yeah, well, that's fine. I'll have a look first. Because
No,
it's here at the
look
business
at that
premises.
now, that's my personal stuff.
Tremendous. Listen,
Yeah, just back up.
in my role as manager, I'll be assisted by three of my staff. Kylie, who's here present, Melissa Gildiz and Georgia Bradley. I'll also be assisted by Andrew Lee of Forensic IT, who's in the room, who's engaged to help me with IT matters associated with accessing the books and records of the practice. The Board determined to appoint me to manage the practice because the Board is satisfied that A, there are circumstances warranting external intervention under Section 326 of the Act, and pursuant to Section 327, there is a need for an independent person to be appointed to take over professional and operational responsibility for the law practice. The effect of the service of the notice of appointment is that until my appointment is terminated, any practitioner who is listed in the notice of appointment, being Peter Hartley Ansell, Dat Barn, Maria de Gregorio, Kudadadad Mohammadi and Tayyam Abdullah Rashid, must not participate in the affairs of the law practice except under my direct and express supervision as manager. That means that staff, such as you, must not take directions from any person in relation to law practice other than from me. Mr Kuksal and Mr Ansell are only allowed to give any staff directions or instructions in a way to the lawyers working for erudite law as I permit. Based on the notice of appointment, I have the power, various powers to do various things. One,
Sorry?
transact any business of the law practice that I reasonably believe to be
Yeah,
urgent.
just in the boardroom with
Transact
three
with the approval
people.
of any of all the existing clients of the law
Yeah.
practice, any business on their behalf.
Somebody is
Accept
reading me
instructions from
something
new
which I
clients
told them
and
I am
transact
not
any business on their
authorized
behalf.
to.
Charge and recover legal costs, including legal
Yep.
costs for work in progress from time to time of my appointment. Enter into execute
Yeah.
and perform any agreement.
Oh,
Give
the
trust
manager,
fund or
I
trust
still
property
couldn't remember his
if I
name. He
consider
doesn't
it
have a name
necessary.
card or something.
Wind up the affairs of the law practice. In order to perform my role as manager,
Two other
under Section
people.
336(2) of the Act, I am permitted under the
Nah,
Act
they're
to
not
A,
allowed to get in.
enter and remain during business
Well,
hours on
well,
this
they will
premises,
probably ask
used
them
by
to
the
go
law
in.
practice for and in connection with engaging in legal
know.
practice, require the legal
Yeah.
practice or an employee of the practice or any person
Okay.
who has had or had control of
All right.
client files and associated documents to give me either or both of the following: access to the files and documents I reasonably require to perform my powers, and information relating to client matters I reasonably require. Can I just pause there? Well, that's important there.
I'm not authorized. I'm not an officer here. You can read whatever you want. You can make a video recording of you reading this. That's fine.
Equipment or facilities on the premises, or require any person on the premises to operate equipment or facilities for a purpose relevant to my appointment. Take possession of any relevant material and retain it for as long as necessary. Secure any relevant material found on the premises against interference if the material cannot be conveniently removed. Take possession of any computer equipment or computer program reasonably required for a purpose related to my appointment. If I do take anything from the premises today, I'll provide you with a receipt which describes the item taken.
When?
Pursuant to section 336, I'm required
When will
to
you
take
provide a
reasonable steps to
receipt?
return
Well,
any
if
material
you want to wait outside, we'll provide it to you.
I've taken steps I'm longer required for the purposes of my function.
But how would I know if I'm not allowed
If
to video here?
Or forensic
How would I
IT
know?
take possession of the
No one
document or
said
any
you can't
electronic
video,
devices.
you're videoing now.
That can be readily copied.
So
or
I can be
provided you
here
with a
when
copy
you're
of it
taking
as soon as
stuff?
practical after
Because
taking
there are
possession
some of my personal stuff.
My appointment as manager is not stayed if you wish to appeal or make an application for review regarding the board's decision to appoint me. That's why an injunction is irrelevant. I am permitted to continue to exercise my powers and other functions during the currency of an appeal or review, except to the extent of any court directs otherwise. To enable me to undertake my powers and manage the law practice, I intend to ask you or anyone else present a number of questions to gain better knowledge of the practice and its operations. Lula, some questions. How long have you worked here?
I don't have to answer you.
You do actually.
No.
How long have you worked here?
I do not have to answer you.
I note your refusal to answer. In what capacity do you work here?
I do not have to tell
What
you.
job do you do?
I don't have to tell you.
Do you operate laptop computers or any electronic equipment as part of your work here?
I do not have to tell you.
I see. Can you tell me the passwords and access codes to all the computers in this office?
I do not know that.
You don't know them?
No.
All right, I see.
Or we might just need to take with us.
We will.
What we need.
Can you show me, please, and I mean now, where the files and documents are that relate to the running of the practice? Do you run various files, this practice, for clients?
I do not have to answer your questions.
You do. Show me where the files are, please.
If you're taking stuff, I'll take a video and then we'll just get the
I
receipt.
can take.
That's Howard Bowles coming to watch.
Maria, you haven't left yet. The police will, when they arrive, will be asked to escort you from the premises.
I'm just trying to understand what you said. You gave me documents now.
Take them outside the premises and read them. You're not entitled to be here. Leave the premises. Mr. Kuksal, if you'd like to come and engage with me, you are very welcome to do so. Mr. Kuksal, you're welcome to attend at the premises. Mr. Kuksal, why don't you attend at the premises yourself? Oh, I see. Well, you should do well there. You're very familiar with it.
55.
What number's this next one?
The next one is, which one's the medicine one? Okay, it's actually 55, but I understand that hasn't reached out of the ones that have been provided. I'm just going to have a quick look. So which ones have you played? Can you confirm, please? So you played 64, 52, okay. Can you play 52, please?
Says by the manager who I still don't know the name.
Yeah, Maria, you go ahead and select it. It's not so positive. You're the authorized.
Okay, I'll ask the question.
So I was there, they were allowing me to take my medication, but as soon as they realized it's Shivesh Kuksal's, they were like, no. So why is that?
I was thinking that, but there's nothing to fix on that side.
Where is the medicine, Lila?
It's in his drawer, they know where it is. They just don't let me take it.
You're not allowed in.
Sorry, I was...
You can speak from out there. Go on. Can you please just take one step back? Thank you. Outside.
So, can we not collect the private medication of the staff?
Can you what, sorry?
You're saying we cannot collect people's private medication. You'd rather they go without their medication.
Have you got medication here yourself?
No, I said staff's
If Mr.
medication.
Kuksal wants to attend to collect his medication, I will provide it to him.
So I'm being blocked from entering the premises, and no, I can't collect your medication for you.
No, sorry, not this one. Not this one. So sorry, 52 is the one that you played, 53. Sorry, 53. It was 62 that I was thinking. Yeah, is this 53?
Yep, call him. You and I might have a look at the file, see what's here. Okay? Well, let's start here.
Let's start here.
There's nothing. There's nothing.
No, I'll speak to Mr. Rapke.
No, he's doing the door first now, so you can call it.
Yep.
Just go down next to us.
Yep. Let's assemble this together so we have the right ones. Yep. George, we'll leave everything in each individual office.
Yep,
And
okay.
then we'll do a stock take any shot.
Do you want me to start putting things together?
Yep.
Yep, okay.
Nick, why don't you two go in there and make a list of what's in that office? We'll do it office by office.
Yep.
So this is Mr. Rapke saying to Gordon Cooper, Mr. Cooper, that you and I will have a look at the files. Then he goes into Mr. Ansell. And Mr. Bowles joins them there. 9, sorry. So this is Ms. Kylie Hall coming out of Ms. Di Gregorio's office. This is around the time when she's setting up files. There's a better angle of that in the interview, which I'm not playing for time. Yep, Your Honor, she's setting up the files as we speak. Now there's 9.
So when you say she's setting up the files,
she's opening up the relevant binders for the cameraman to come and then record later on. And they're speaking with Ms. Anaz to know what's where. Video 9 and 62.
Excuse me, sorry. Are you taking legal advice right now? That's right.
Oh, yeah, thank you. I don't know, about 50 people.
So Mr. Cooper just directed the cameraman to go away and he listened to him. 62.
Can I take it?
No.
Why? So you're keeping his medication from him?
He can attend here and I'll give it to him.
So I'm sorry. I am taking it for him.
If you could come and get your medication.
No, I said medication.
No,
And
you'll
okay,
get yours.
you're saying that I can't get his medication for him. So you're keeping his medication from him because.
The manager already told you he can get his own medication.
Okay, so okay, this is mine. All right.
We were good enough to let you in here to get
Okay, thank you. Let me take my contact lenses, please.
R49.
There you go.
All right, breaking in after I told you we had a hearing.
We're not breaking in, madam. If
You
know what
are.
you're doing,
That's fine. I'm just recording it. It's my personal phone. Don't touch me, please.
got no interest in touching you.
All
whatsoever.
right, great. Thank you.
You create problems for no good reason. We're out of line.
Is there anyone else in the office who
No.
I should speak with about the appointment
There
of
is
the manager?
no
You are the
other.
only person in
Yes,
the office?
yes.
All right, well, there's no one else to speak to. I'll introduce you to Mr. Rapke.
I'm not interested in knowing him.
Well, I'm not interested in what you're interested in. I'm telling you, under the Act, Mr. Rapke has been validly appointed.
Sorry, okay, does he have a name card or something? And are you guys inviting Channel 9 in? Just asking? You are? Sorry, your name? I can't remember. Yeah.
My name's Howard Rapke.
So they've, just stepped in, so you've invited them in?
Guys, just give us a few minutes and then we can talk to you further. Have a look at these. Perhaps put your phone down and show some common sense and have a look at the document.
I don't have the authority to look at your documents.
Well, if you
I'm not
don't,
the
who does?
officer.
Well, where is the person in charge? Is that Mr. Kuksal? Where is he?
Well, I am not the person in charge.
That
I
wasn't
don't
my
have.
question, madam. Where's Mr. Kuksal?
Well, why do I have to
Don't
tell
play-
you?
Play games.
I'm sorry.
This
Why?
is my notice
Why
of
do you
appointment
think?
as manager.
Oh, sorry.
Today, the board appointed me as manager of People Shop Pty Ltd Trading as Erudite Legal. That was a resolution made by the board under the relevant sections of the Act and relates to the
So this
premises
thing
that's been-
is,
No, enough. You listen. Instrument of appointment of manager. I've been appointed and I have a current practicing certificate.
Today.
My appointment is for
And
6 months.
that was not notified to us.
Just be quiet and listen.
I told you I am not authorized
to
to listen to you.
And
I am not
the fact
authorized.
is now there's no longer anyone within this building who's got control of the practice apart from myself. I'm appointed by the board.
Mr. Rapke can exclude you from these premises now. So you're going to cooperate with him, or we exclude you from the premises? What do you
Well,
want to
I
do?
want to know. My personal stuff is here. I want to
Why don't
know
you
what
take
you
your-
are taking, what
Why
you're
don't you take
doing.
your personal things and leave? I think that might be better for
No.
you concerned.
I will give you 5 minutes to
You're
look at
obliged
your
to leave.
personal things, and then you will leave.
Take your
Unless
personal
you
things
call the
now.
police, I am not
The
leaving.
police
are
are here.
here.
They're standing to your right.
Where?
This is Detective Guerin, and this is
All right.
Detective Homburg.
Take your personal possessions and leave.
Hello. Madam, you have 5 minutes to get your personal belongings, and then you will be escorted from the premises. Do you understand that?
You're now trespassing. Your permission to be here is withdrawn. Leave.
The time starts now. You have 5 minutes.
Okay,
Well,
can
have
you guys
4.5
go on?
minutes now. Out my stopwatch.
Take your gear and go. It's as simple as that. You are no longer permitted to be on these premises. Right? Kylie, could you just escort her off the premises, please?
We'll give her
It's all very confrontational and unpleasant. I accept that.
No, Your Honor, I will make appropriate submissions about it. 62. Have we done? I'll note that he said we will talk to you further in some time. Okay, so we can stop here, but I'll just make a note that in evidence is also a video which records Mr. Rapke catching a glimpse of Ms. Zhu recording him from the door, and Mr. Cooper and Rapke and Mr. Bowles are standing next to each other. Mr. Cooper notices Ms. Zhu, tells Mr. Rapke and then walks away out of the vision of the camera. That's in Ms. Zhu's phone. Mr. Rapke then instructs the locksmith to take out the CCTV cameras that were installed in the office. There was no reason for him to do that, and then walks up to Ms. Zhu, who's standing next to, ironically, the Channel 9 cameraman, and asks Ms. Zhu to stop recording while the Channel 9 camera continues. Now, a couple of other observations. Mr. Rapke says to the Channel 9 people, "We will talk to you further in some time," in the video that was played, and essentially that clearly means that they were talking previously. It's also clear that the manner in which they're intimidating Ms. Zhu, they're surrounding her and asking her to do a number of things. They do not have under the Act any authority to instruct anyone who's not a lawyer. The Act only allows them to instruct lawyers, legal practitioners. The premises were leased by the company and related entities. The practice, being appointed as a manager to the practice, gives them no entitlement in relation to the company. Mr. Rapke can subsequently acknowledge that when it was no convenient for him. So what was happening there is the directors, a director, Ms. Di Gregorio, of the company was forcefully removed from the premises by a manager appointed to the practice. And it could not have been said that they were obstructing the work of Mr. Rapke. Ms. Di Gregorio relevantly was seated in a sofa at the entrance. What Mr. Rapke was doing inside had no bearing on, what Ms. Di Gregorio was doing on the sofa had no bearing on what Mr. Rapke was doing inside. She was removed because Mr. Rapke alleged to the police that his work was being obstructed by Ms. Di Gregorio. It's the same reason for which Ms. Zhu was removed. Now, they knew which file it was, because the firm had hundreds of binders, but they were able to pick up specifically the binder with the only material and a couple of other specific binders. That was because they were communicating with Ms. Anaz in real time. They were also given, Ms. Anaz was the head of HR. She was responsible for generating passwords for all new employees, for inducting them. In evidence is also a note with a password to an employee's login.
Mr. Kuksal, saying, in evidence, there's thousands of pages.
Exhibited to.
I'm telling you, I've just had a quick look, there's thousands and thousands of pages that have been exhibited.
Your Honor, in the affidavit, the exhibits are described.
If you want me to look at a document, you identify the page number of an exhibit, or else I'm not going to have regard to it.
I can identify the.
It's too voluminous.
Yep.
You do it in the next, or I'll give you another 25 minutes. I'll give you until 20 to 4.
So I'll do that at the end, but I'm just raising the superficial issues first. So, and then it's also clear that Mr. Bowles is directly instructing Ms. Zhu to do things or not to do things. In another video, Ms. Zhu asks for Mr. Bowles' details, his name. He wouldn't give his name. Also, PA 28 to the exhibit, PA 25 exhibit to Mr. Ansell's affidavit includes a copy of my LEAP records maintained by Victoria Police. Now, in the LEAP record, the entry that was made using Mr. Hornberg's police ID for what the police was doing there is the execution of a search warrant. So under Mr. Hornberg's ID, his IDVP number is caught in camera. So effectively the police had put down the reason for allocation of resources as the execution of a search warrant on the office. Ms. Di Gregorio and Ms. Zhu were both told that the police was there only to maintain the peace. Mr. Nayland's report notes that Mr. whoever the manager that this will be appointed this cannot go there alone, cannot give advance notice to the firm of their coming, which is required under the law, under the uniform rules, and this is because, he says, I have been featured in a current affair videos which are the subject of the ONI proceeding, and because he says I've assaulted a paseo, which is completely not true. It's not even an allegation brought in the proceeding. Now, it was told to Ms. Di Gregorio and Ms. Zhu that the police were there to maintain the peace. In the official police records, they're there to execute a search warrant. A current affair reported that they were detectives from the Financial Crime Squad. They're connected with the logistics business and how the firm was assisting it in concealing the money that it had obtained through financial deception. Those, relevantly, are charges brought in the ONI proceeding. And Mr. Rapke kept provoking me to come to the office. That was because during the execution of a search warrant, the police can arrest people, and they had planned to arrest me on camera to produce a great spectacle. That's why Mr. Howard Bowles wouldn't let Ms. Zhu collect my medicine. There are other conversations caught on video that show Ms. Di Gregorio talking to the police saying that I need my medicine urgently. And it's also worth noting that, as soon as the Channel 9 camera crew left, Mr. Rapke allowed Ms. Zhu to take the medicine. So she did bring my medicine back, she just couldn't bring it while the Channel 9 people were there. As soon as they left, she could take it. So the purpose behind the antics was to get me caught on camera. It is also worth noting that Mr. Rapke got Ms. Di Gregorio to place me on speakerphone and then recorded a private conversation. I had no knowledge that Channel 9 was recording. I would have been more colorful in my language otherwise. But the fact is that that was a breach of the Surveillance Devices Act. It was also a breach of privacy laws. Not to mention that he was acting as my lawyer at the time, even in relation to the Channel 9 proceeding. He filed a notice of ceasing to act in this court in relation to a breach of confidence proceeding that I had against Channel 9 at least a couple of weeks later. Around the 5th of September in this court he filed a notice of ceasing to act as the solicitor in the proceeding, in the Channel 9 proceeding. So he was my solicitor in that proceeding, and he is getting the same person that I am suing in that proceeding for defamation and breach of confidence relating issues to record a private conversation with my lawyer because he is my lawyer at the time without my knowledge or consent in a work setting. Also, right from the moment he walks in, it was known. It was commonly known, it is in Mr. Nayland's reports that I am client of the practice and not a client of the practice. But the moment he walks in, the first thing Mr. Rapke is asking about is, where is Mr. Kuksal? Not where is Mr. Ansell, who is the principal solicitor, or any of the other solicitors that they know are employed by the firm because they have details because of the registration of the practicing certificate with the VLSB. He doesn't say, where is Ms. Di Gregorio, who is the director. He says, where is Mr. Kuksal, because they wanted to catch me on camera. Now, I go back to paragraph 2 of the reasons, p. 495. It is worth noting that none of this content is in the Channel 9 broadcast about the firm. All the broadcast shows is an interview, maybe a few seconds of the interview with Mr. Rapke. It is not even said that it was taken at the firm. And there is a video, there is a shot, a brief moment of the regulators getting a locksmith to get in. So nothing from inside the firm. Mr. Cucchiara was very self-conscious about being caught inside the firm, as the first video shows. So Your Honor could have only known that all of these events were captured by a current affair.
Paragraph 2 of my reasons?
Paragraph 2. Your Honor could have only known that these events were captured by a current affair and taking over, seizing all the assets of the firm. Your Honor could have only known by watching these videos or reading the description of the videos. Because this was not on the news, that he had seized all the assets. Now, having seen these videos, we would say that it could not have been said by VLSB that we had no claim against them. And then they brought an application for summary dismissal on frivolous, because it is vexatious, frivolous, we have no claim against them. And it cannot be said that, knowing everything that I have said right now, I would not suspect them, reasonably, of pulling dirty tricks or of deliberately trying to stall the matter because they have no answer to our case. They have still not filed any response to any of the material that we filed, and Your Honor is obliged to interpret from that basically draw inferences that they would have answered if they would be assisted by an answer that they could provide. Now, the next matter is that the Supreme Court Civil Procedure Rules actually require the service of summons on the other party before a hearing. For an application to have been validly made, the summons must be served on the other party before 2 o'clock on a working day, on the last working day. And if they are not, so this under Order 46 of the Supreme Court Civil Procedure Rules. And Order 46.05 or Subclause 46.05 requires the service of the summons prior to the day of the hearing. That had not been done in Judicial Registrar Keith's case, and also the part of the rules which may be dispensed with by a judge does not apply to a judicial registrar. So Judicial Registrar was not competent, did not have the judicial authority because his Honor is an administrative officer relevantly and is only delegated judicial authority either by the rules or by specific order of this court. Judicial registrars do not have the authority to dispense compliance with the rules, which just judges can do under the Uniform General Civil Procedure Rules. This is 2.04, dispensing with compliance. The court may dispense with compliance, and Order 84 of the Code deals with the powers or the authority of the judicial registrar. And it lists all the, natural entitlements that they have or the jurisdiction that they have in relation to different matters. And that order says nothing about jurisdiction in relation to the auditor, as a part of which I referred to earlier. So we had a statutory right, in effect, to be notified, which wasn't appreciated. Your Honor knew about what they had done. Also, what is relevant is that Your Honor misquoted me from the transcript. So in paragraph, I refer to the reasons again, Your Honor.
Yes.
And I refer to, so first I refer to paragraph 4. And I note that the paragraphs that Your Honor has quoted, for instance 1 and then 1.1, they end in ellipses because they are incomplete sentences. Now, if Your Honor goes to paragraph 5, Your Honor has quoted something that I said, and there is a full stop there, not ellipses. Now, the part of the transcript that is taken from actually has been misrepresented in these reasons. And the part of the transcript that it is taken from actually reads the following way. I will bring up the.
If you just give me the page number of the transcript as well, that would be helpful.
Yep, so it is on P6, and this is what's said in this paragraph. Your Honor, they are intending to stall the progress of the matter. I think the court rules are clear. I refer to the court rules.
This is the transcript before the judicial registrar.
Keith, yes, that's what Your Honor quoted from.
Yes, I know, yes.
I think the court rules are clear. If there is a separate question that can be identified, then the court must, in the interests of overarching obligations of the parties and the expeditious resolution of the matter, have the separate questions determined first. We think that those 3 questions are, in essence, the crux of the matter, and they will surely dispose of the proceeding completely. Now, this is where Your Honor stops with a full stop. There's, in fact, a comma in the transcript, and after that it says, and at the very least substantially. So they will dispose of the proceeding completely or, at the very least, substantially. I said but obviously it doesn't make sense, it has to be or, so it should be interpreted as or at the very least substantially and give each side a realistic understanding of where they stand. So, or at least substantially, at the very least substantially and give each side a realistic understanding of where they stand, full stop. I think it can be reasonably interpreted that Your Honor wanted to imply that to then schedule only these 3 questions and then say, because we've lost her, our both proceedings should be disposed of. Because, everywhere else where Your Honor has quoted incompletely, the sub-paragraphs end in ellipses. This, again, to say that something is misrepresented is not necessarily to say that there is dishonest misrepresentation, but it is undisputable that there is misrepresentation in that paragraph. Now, I also take the court to paragraph 24 of the reasons, 495. Although there is no doubt that the defendants should have served the summons prior to the directions hearing, there are a number of problems with Mr. Kuksal's position. One is that it proceeds at least in part on the assumption that the defendant's application for summary dismissal is frivolous, but that is not a matter that I am now, or Judicial Registrar Keith was then, in a position to decide. Your Honor was in a position to decide that matter. Not Judicial Registrar Keith, but Your Honor was. Judicial Registrar Keith wasn't because he doesn't have judicial power under the Act or, well, he doesn't have any source of judicial power. That is why every party has a right to appeal, because the purpose of the delegation of power is to expedite matters by allowing judicial registrars to deal with things that will normally be, procedural. But in any matter where the matters are more complicated and procedural, regular, predictable procedural orders will not do, every party has, then, the right to call for a judge. This was clarified in Harris v. Colluding, to which I've taken the court, and the court did not respond to it or refer to it in rejecting my application for recusal.
It's 3.33, Mr. Kuksal.
Yeah, well, Your Honor, I should be given an opportunity to.
Yes?
I'm not wasting time. I'm not repeating myself. So the second thing Your Honor says is that it presumes, in effect, that the defendants deliberately chose not to serve the affidavit, and that was misconduct that ought to face consequences. This is a finding about our intention which disparages the manner in which we've reasoned. It must necessarily be that, because it then goes on to say that thinking was incompatible with the Civil Procedure Act or our overarching obligations. So what Your Honor found was that, knowing all of this and more, because this is in evidence, I know more things about what the LSB has done. After all of that, Your Honor, we say, must have known about all of that from what Your Honor has said, or Your Honor had access to other evidence which we don't know about, which wasn't filed in the proceeding because they haven't given evidence against themselves. So, after knowing all of those things, Your Honor then concluded that it was unreasonable to the extent of being a breach of my statutory obligations, and for Mr. Ansell to be a breach of his statutory obligations, and so on for every plaintiff, for us to conclude that when they breached their statutory obligation to service the summons before the hearing, and, by the way, it wasn't common ground that the summons had been not served. In fact, at the very last paragraphs of the transcript, I am still saying to Judicial Registrar Keith that, first of all, I don't know what you're scheduling in terms of the orders because I've never seen their summons. So I did not even know that it will be an easy application. But I also say that there should be something in the order that, if we can prove that it wasn't served, then there will be repercussions for them. And Judicial Registrar Keith says something which is midway between agreement and complete rejection of what I'm saying. Also, relevantly, Judicial Registrar Keith says on P8, line 31, he's raising this question to Mr. Senatharaja, he's the counsel for the LSB, I'm told that the summons has not reached the plaintiff. Do you have any information about that? So, last line of P8, first line of P9. Mr. Senatharaja, I'm seeking instructions about that. I can't do anything more than that. They never accepted, it was not common ground. That's a finding of fact that Your Honor had in the thing. That goes against our claim that Your Honor has prejudged the matter and is creating a narrative that is not aligned with the actual facts, because if it is common ground, then they're less dishonest, then we're more unreasonable because they've accepted that they haven't served, there's nothing to hide, no implications of consciousness of guilt. So, and also, Your Honor relevantly quoted several parts of the transcript and pointed out that there's no prejudice. Your Honor, it can be reasonably said that an implication arises that Your Honor deliberately left out all the parts where I say what the prejudice is in the transcript. I'm raising with Mr. Keith what the prejudice is in real time. I keep saying that they're stalling, they're doing this deliberately to stop the progress of the matter, and that I don't even know what their summons are. How can I agree to complying with some orders when I don't know what their summons are? That was the whole point of it. After seeing the summons, one can say that it was, nothing, and it wouldn't have delayed the matter. The fact was that they didn't even serve us during the hearing. They could have said, let's adjourn for 5 minutes, get 'em, neither Judicial Registrar Keith nor they, and this is something that Your Honor missed, but then also, Your Honor's reasons sort of mischaracterized them because it said that they were so procedural, the summons and the orders, so on and so forth. I couldn't have known that, and I specifically raised that in the transcript, which Your Honor did not include, whilst representing that there was no prejudice that I've ever identified in the appeal or to Mr. or to Judicial Registrar Keith. It's also, so this is in paragraph 35, where Your Honor says, no relevant prejudice was or could be asserted. Paragraph 35 of the reasons. That's untrue. Then paragraph 41, subparagraph A, we have made an application to amend the originating motion. Your Honor says, what we wanted was the same orders that Your Honor made in 3994 for the benefit of the LSB, that normally when you request leave to amend the originating motion, what you're requesting is that the court make orders that by this date you can file an amended originating motion and so on and so forth. Your Honor did not ask us about this particular matter on the day and then basically concluded that we'd done the wrong thing. I don't know how we could have filed an amended originating motion because the registry wouldn't accept anything for filing without the court's leave, and there were no orders which would have allowed us to serve the other side in a way that they would acknowledge it as something that they had to receive. The LSB does not acknowledge the service of anything. Now,
well, it says 341, Mr. Kuksal.
Your Honor, I'm not repeating myself. That's the best I can do. Now, it's also.
If I give you until 4 o'clock.
Yes, I'm trying my very best.
Yes, it's not a matter of whether you're trying. At 4 o'clock I'm going to draw your submissions to an end.
Okay, now, paragraph 12, Your Honor says, again this was not a matter that was before Your Honor. This is about whether or not the originating motion was validly filed on behalf of all the plaintiffs. Now, this was not a matter that was raised by anybody before Your Honour. It's just something that Your Honour took up on your own, and also there are issues with it which misrepresent the matter. So, yes, the originating motion was drafted by me. But at the end in the schedule of parties it is identified that Mr. Ansell is representing the company in the same originating motion. There's a schedule of parties and it lists who's represented by whom. Mr. Ansell had relevantly endorsed the originating motion on behalf of the company. The company or the specific solicitor does not need to himself draft the originating motion. He can endorse it, especially where there are multiple plaintiffs. There would be nothing improper about one plaintiff drafting a document which then all the other. That's what happened with every natural person. They endorsed it, so did the company, and that is not to say that it did not have a contribution in terms of drafting the document. It is a reasonable inference that in the prepared by, in the small space that is afforded to the prepared by section of the tram tracks, you're not expected to list, 6-7 parties. The proceeding is 5 plaintiffs. I did the predominant majority of work. My name was on the thing. There was no reason to cast aspersions on the validity of the originating motion about which Your Honour had no proper basis to conclude what was concluded. But also, we had not been given an opportunity to address that issue because it was not in contest. In fact, they specifically took away Mr. Ansell's license so he could not later prosecute the matter effectively. Then paragraph 15, finally Mr. Kuksal anticipated making an application relating to the representation of People Shop Pty Limited or the prosecution of its claims.
What paragraph are you reading?
Paragraph 15 of the reasons.
15, yes.
So if, Your Honour, finally Mr. Kuksal anticipated making an application relating to the representation of People Shop Pty Limited or the prosecution of its claims at the hearing of the matter. That is a matter that in view and subject to some direction later being made to the contrary or probably to be made at the time of the hearing of the matter. So Your Honour is not deciding the matter in advance, so we can have advance warning of what will happen and prepare ourselves accordingly, and effectively what Your Honour is saying that, I can decide that. I say, that's not literally what it says there. It says there, the judge who's hearing the matter can decide that. But I say, because Your Honour is in fact hearing the matter today and may have had some reason to believe that Your Honour would be hearing this matter because it was allocated to Your Honour. Now, I refer to the reasons that were published by Your Honour. The citation for these is 2021 VSC 669 Avant-Garde Logistics Solutions Pty Limited v5 Fish Superannuation Pty Limited. Now, in that matter, and I'm just going to go to the specific paragraph, so its paragraphs starts from paragraph 13. 14 is very relevant and I'll read from 14. As I explained to Mr. Kuksal, I was prepared to, paragraph 13, SS 56(2) of the Evidence Act provides that evidence that is not relevant is not admissible. I consider that the material is relevant to Mr. Kuksal's application for leave to appear for Avant-Garde, notwithstanding that is not a lawyer. As I explained to Mr. Kuksal, I was prepared to assume that he had explanations for all the impugned conduct that if accepted would excuse him of any inappropriate behavior. Further, as I also explained to Mr. Kuksal, I do not consider that it would be necessary for me to get to the bottom of the truth of these matters in the context of this application, and that I did not intend to draw any conclusion based on the evidence under consideration that he had in fact engaged in misconduct. Rather, what seemed to me to be relevant was the fact that rightly or wrongly issues seem to have arisen in the past on occasion when Mr. Kuksal has appeared and presented argument before a tribunal or a court. The fact that problems have arisen in the past, regardless of whose fault they were, prevented him from submitting that he had appeared for himself or companies associated with him on numerous occasions in the past without there having been any complaints or incidents. In circumstances where I have a discretion to exercise, in all the circumstances that makes the material relevant. Just as it would have been relevant if Mr. Kuksal had been able to establish that he had appeared for corporations on many occasions in the past without there having been any incidents and nothing but praise for his performance. It is relevant that that is not the case. So what Your Honour found previously was that the fact that some administrative officers, the allegation that was made was some people at VCAT had complained about the manner in which companies owned by me had been represented and attributed what they considered to be inadequate or unsatisfactory representation to me. These were administrative officers, and one of them I will soon commence, one of them I say acted grossly improperly. It was reported in the newspaper that they had written letters about me to justices here. Your Honour did not want to consider my response to the allegations that were raised, many allegations.
10 minutes, Mr. Kuksal.
Yes, this is an important point, Your Honour.
Yes,
and found that just because some allegations had been raised by the executor, no different from the LSB, then that necessarily says something about me or my capacity to represent the company, and then Your Honor rejected my application for me to represent the company. Now, also on the 7th of October, this is from the transcript and it's in Exhibit PA 27, I believe.
The 7th of October transcript before.
The 7th of October 2021.
Okay, before me.
Before Your Honor, yes.
Yes.
And what Your Honor says in the transcript is that Your Honor will not allow me to raise allegations of fraud against a lawyer. And I'm reading from from page number 38 of the transcript of the 7th of October. I'm concerned that it's being made by somebody who's not subject to any of the usual obligations that legal practitioners are subject to in terms of professional, ethical responsibilities, and I'm trying to get it clear in my head how that all works, and I'm still not sure about it. To clarify the context, and this is clear from the transcript, what had happened is that there was a barrister who had represented 5 fish in a VCAT proceeding and made allegations that I was engaging in an abusive process by getting the tribunal to consider a matter which the tribunal had previously decided. I then challenged them and produced a transcript of the previous proceeding. That transcript had been served on all the parties, along with the audio recording that had been obtained from VCAT, pursuant to which the transcript was produced a month ago. Your Honor finds that in this transcript that I had served it on everybody a month ago. And then the barrister acting for 5 fish basically says that the transcript cannot be considered because it has been prepared by a firm owned by me. It said so on the transcript in the interest of transparency, and that it must have been unlawfully secretly recorded during the last hearing and therefore it's an illegal document. The other side then sent a letter to VCAT after we have planned to sue them, apologizing, this was after the hearing, for the misrepresentation. Your Honor notes in Your Honor's own words that, so that part that I raised, after that, there's a discussion about, so what I wanted to was raise another ground of appeal that because that barrister had misled the judicial officer, well, the administrative office of the VCAT member. Against considering the transcript, they took submissions by the barrister at face value and effectively that is a relevant matter that to equitable fraud. What Your Honor said was that Your Honor accepted and that Your Honor had seen, in fact, the emails to which the transcript had been circulated. Your Honor knows that I feel aggrieved and there was some justifiable reason for me to feel like that because I had done the right thing and then the other side had, done what they did. But effectively, Your Honor prevented the finding of the document until I removed the name of the lawyer. So first there was a hearing for injunction on the 4th of October before the application, the originating motion had been filed. It was done pursuant to the rule which allows the court to consider a matter as if the originating motion has been filed and give leave to the party to file it later. So on the 4th of October, it was agreed that I would file the originating motion. When I tried to file it on the 7th of October, initially, the registry said that it had to be filed pursuant to a different rule and then sent me an email with the specific rule. All of that is in evidence, BA 27. And then the other side objected. The court held an urgent hearing on the 7th of October, a directions hearing, and Your Honor basically said that I have to take the name of the person out, otherwise the documents would not be sealed. So,
5 minutes, Mr. Kuksal.
Yes, so what is relevant from that is that Your Honor would not accept, even where there was a substantial, even where facts were agreed that were capable of demonstrating that the barrister had breached a barrister conduct rule in relation to which I had sought a declaration. And then Your Honor specifically says in the transcript that a judge does not have to address every point that is raised and does not necessarily have to make orders. I pointed out I think it was S24 of the Supreme Court Act which says that the court cannot refuse declarations and Your Honor did not accept this. In this proceeding, we're asking more serious declarations against the LSB. Also lawyers, the individuals are lawyers. Neither of us, by the LSB's, none of us, by the LSB's account, are lawyers in the relevant sense of being able to practice. We have all been non-lawyers raising allegations against lawyers, which Your Honor has noted previously is not something that Your Honor can accept. So that was about the pre-judgment. The two-phase argument is that Your Honor will not accept our allegations at face value and that is why, even after seeing all those videos and concluding that all of those things had happened, that they had seized all of the assets. A manager has no business seizing the assets of the practice, he's not a liquidator. Your Honor even cites the specific section pursuant to which things can be seized. It says nothing about seizure of assets and shutting down of the office. Then Your Honor found us to be unreasonable, so that's essentially the first issue, misrepresentation. I pointed out that the second issue, that a factual matter, I pointed a number of those there. I also note that in the latest reasons that were published on the 20th of November, Your Honor basically omits the time when the summons had been lodged. What Your Honor says in the reasons is that the summons were filed shortly before the hearing, and that again, it can be reasonably said, is to misrepresent the fact that they had a week to serve us and put an innocent spin on why the service was not accomplished. Your Honor makes numerous comments in, so every time Your Honor refers to Emza Naz, Your Honor first clarifies that extremely private and sensitive material was taken from her phone, so on and so forth. She's filed that in evidence against me in the intervention order matter, and my problem is that if I am following the law, I will not refer to it because there's a pseudonym order in respect of that order. But there is no way for me to enforce that against Ms. Naz because I complained about it on the last occasion, that the VGSO had breached it and nothing happened. The police won't take any complaint against her, even for the breach of her intervention order, and the comments that were made, there was nothing by comparison about the egregiousness of Mr. Rapke letting Channel 9 record to content of the files after being appointed as the solicitor in charge. But he was letting an investigator who was investigating me without proper notice go through the files, and that he was basically intimidating directors and having them removed forcibly from the premises of the company.
1 minute, Mr. Kuksal.
Yes, so nothing.
Or I'll have to.
Your Honor, I'm trying my best. Nothing was said about any of those issues there.
Right.
Now, the other matter is that all the orders that were made on the 23rd of August in this proceeding and the other proceeding were by and large the orders that I have sought on the summons. But Your Honor still concluded that we have lost our application and then misrepresented why the orders were made like we had requested, and it was said that it was because of the affluction of time that different orders must now be made. It was also misrepresented that Ms. Anaz's summons had not been withdrawn. In both the reasons, so the reasons that were published back then around the 23rd of August, it was represented that, so my whole claim was that those parties were committing fraud on the court, and then I put them on notice and the lawyers on notice that when they'd lose the application, I would bring a civil procedure application against each of them, including the lawyers. Then they withdrew it, which provide the fraud, and I made an application after that because it could not lose at that point in time because there was nothing against it. And also there was a practical necessity of raising that application because the next.
Finish up now, Mr. Kuksal, thanks.
I am trying to.
It's after 4 o'clock.
Your Honor, I am rushing.
All right, finish up.
I am.
I'll give you another minute or so, and that's it.
I'll need.
It's taken all day, Mr. Kuksal.
Your Honor, I've not repeated myself.
Mr. Kuksal, I don't care. A day is long enough to present the argument.
I'll take 10 minutes at the most.
No, Mr. Kuksal, I'll give you until 5 past.
I'll try my best, Your Honor. So what was said in the...
No, at 5 past, you'll sit down.
What was said in the reasons was that I had deliberately brought that application to embarrass them. Now, the fact was that because Judicial Registrar Baker's orders had next scheduled Ms. Anaz's application, which had been withdrawn, if I didn't bring the summons, there was no other way to have that order reshuffled. So I brought the application that I could not have lost. The other side had not filed the relevant material. Then on the 16th of August, Your Honor takes ownership of the case and allows the state to, on the 17th of August, file summons after suspending the rules because they weren't filed and sealed by 2 o'clock the previous day. And then during the hearing, when I say that I could not have lost because there was nothing in opposition, then Your Honor says, yes, but now there's a complication because there's a summons. Then I specifically say during the hearing that I have not read the material or the summons and I am not responding to them. Your Honor shuts me up and says, well, it's in essence the same thing, and I keep repeating emphatically that I will not address the summons. Then in your reasons, you say that this is what I said in opposition to their summons. There's literally parts of the transcript where I'm emphatically stating for the record that I've not read their summons and I'm not responding, and it's a fundamentally different case.
Okay.
In your reasons, you say that I responded to their summons by saying so, and then you ruled that I was wrong and I'd breached the Civil Procedure Act, I brought the proceeding maliciously. You don't mention that they have withdrawn their their summons. What is said is because it was filed long ago, now because of the effluxion of time, there will be a new orders that will need to be made. Also in the last reasons that were published on the 20th of November, it said that Ms. Naz and her parents had brought an application of summary dismissal application against me because I dragged them into a proceeding. It's implied that I did that maliciously to harass them, and then they brought these summons and just left it there. That was the context of the other hearing. Nowhere is it said that they then withdrew it and they filed a submitting notice which, Your Honor, as per the law, means that they're submitting to my position. That's literally what it means. They're not challenging that position. That's not what was included in the reasons. It completely misrepresents my position. There's a magistrate who cited those reasons as the basis of refusing my application to examine Ms. Naz at all. Not even remotely. He literally cited the paragraphs from those reasons.
What paragraphs?
The reasons are exhibited of the magistrate, so Your Honor will.
No, which paragraphs of my reasons did he?
Okay, I will.
This is your last point, Mr. Kuksal.
Your Honor, there's a couple of brief things I want to raise.
Well, it's too late, Mr. Kuksal.
Your Honor, I have them, okay, so I'll get to that paragraph a little bit later, but may I just complete what I have to say?
All right.
So relevantly, they have been given leave to file the affidavit a few hours before the hearing in breach of the previous orders because it exceeded the length limitations, and then it was said that I responded to that. My summons were not accepted for proceeding. The affidavit that I filed that day, the 17th of August, was rejected. It was also against the registry's policy of automatically sealing documents of the nature of affidavits and so on.
Mr. Kuksal, I think you've had an opportunity to present your submissions.
Your Honor, I'm just about to finish, just give me a couple of minutes.
All right.
So what has happened there is that Your Honor has created a disadvantage for them in producing the summons and so on by an abuse of a judicial discretion, which then led me to lose the case, which was uncontested. Then, relevantly, in the last reasons that Your Honor published, Your Honor said that I submitted to the court that Your Honor should not have considered their affidavits because of the submitting notice that they had filed. So there was a mention of the submitting notice, not in relation to their summary dismissal application, that the submitting notice had been filed after the dismissal application had been made. So what Your Honor says is that Your Honor doesn't agree with me because it's a serious matter. Your Honor should have a consideration of what everybody feels or is saying. The fact is that I hadn't read those affidavits because I didn't know that they could be considered by the court, and when I raised it with the court, it wasn't that, okay, I'll give you time to consider and respond to those affidavits, and until then we're adjourned, and so on. Because Your Honor quoted directly from those affidavits in saying that the application was brought maliciously. And I had no basis to know that that was said, because remember, they were not even served on me. They were just lodged with the court, they were never served on me. I had to get it through the filing system. I had no notice of the fact that affidavits had been filed or that they would be relied on.
All right.
Which you had told me the previous day that they had been filed, and then I raised it with the court, and I think I clarified that I had no knowledge of the matters, I hadn't gone through them in detail. So those are the matters. Now, Ms. Inaz has herself cited those matters, the specific part where Your Honor.
Mr. Kuksal, it's time for you to stop now.
Yes, but.
You've repeatedly said you're about a minute away.
This is the last.
Mr. Kuksal.
The last sentence, Your Honor.
You said 3.30, it's now almost 10 past 4.
Your Honor asked me which paragraph.
One more sentence.
Yes.
You say you've got one more sentence.
So Ms. Inaz had quoted the paragraph of Your Honor's reasons of the 23rd of August in her proceeding where Your Honor points out that I added her parents, and then also the paragraph where Your Honor pointed out that the extraction of the material from her phone was done with the knowledge that this would necessarily embarrass and humiliate the person. It does not even present our position that that was done because she was leaving privileged company files from her phone and the contract authorized us to do that, and she hasn't challenged the legality of that. All she's said is that she was pressured with legal proceedings, which is not unlawful.
Yes.
At the time she had accepted it was on the transcript that the specific contractual section was quoted to her, and she had accepted it. She then raised the breach of confidence case against us.
Yes.
She's using that, and I told the court that if she gets the family violence order, I cannot get citizenship.
All right, thanks, Mr. Kuksal.
I note that I had a few other issues to raise, but...
Yes, Ms. Zhu, you've been content for Mr. Kuksal to present argument all day in support of the application. Do you adopt what he says?
Yes, I do, though I will just take 5 minutes if that's possible.
Well, what do you want to add?
It's just the recusal application.
Yes.
Yep. So just based on I've read Your Honor's judgment about the recusal application from the last time, I would say that's in my very respectful submission, that the test that Your Honor applied in the case, that the fair-minded reasonable observer test should not apply to the case where we say that the court was conflicted. So whether or not Your Honor is biased or being partial or impartial does not affect the consideration whether or not the court should disqualify, or Your Honor should disqualify yourself. I remember that, on the 3rd of November Your Honor said that was in the end. You joked about that we alleged that Your Honor is forcing Mr. Kuksal to break the law, and then in your reasons, you have acknowledged that there are some inconveniences that's caused to him. What I will say is that this is not just inconvenience, there is injustice, if I can. And then when such situation happens where the court is unsure whether an action is lawful or unlawful, when the court is unsure about that and then still directs someone to do that, ultimately created the criminal investigation and inconvenience in Your Honor's words and in just using our words. And that's again I say makes the court conflicted either within itself. I will say that's the reasonable fair-minded observer or the bias arguments or test doesn't apply in this situation. So if the court is conflicted, doesn't matter whether or not the court or Your Honor is biased against the defendants in that proceeding or not. Kinney. It should be, and there's indistinct to the justice, and I'll say that justice will be seen to be done if or when such incidents occurred. Justice will seen to be done if the court can step aside, because there are many conflicts that's arising from that, and Your Honor had acknowledged that we are alleging that Your Honor asking Mr. Kuksal to break the law or break the intervention order.
All right, thanks. Thanks, Ms. Zhu.
Thank you.
Mr. Ansell, you want to add anything?
Your Honor, I would just like to say that I endorse both the submissions made by Mr. Kuksal and Ms. Zhu, and I have nothing further to express.
Thanks.
But may I take a minute of his time?
No.
Yep.
No, you can't. Ms. Norton.
Yes, thank you, Your Honor. I have just two matters to raise briefly.
Yes.
The first is, and as on the last occasion, very significant allegations have been made from the bar table against the defendants, including conspiracy and criminal conduct. And there have also, in relation to the videos shown this afternoon, been allegations about Mr. Cooper and Mr. Rapke to the other defendants in relation to the fulfillment of their roles. Your Honor may say I don't need to say this, but for the benefit of my client from the Legal Services Board who's present in court today.
Yes.
I'd like to again make the submission that the allegations that have been made against the defendants amount to Mr. Kuksal's subjective conclusions and commentary. They're unsupported by sworn evidence and they are disputed. I don't otherwise wish to say anything in respect of the recusal application.
I have to respond to that.
No, you don't.
Your Honor, I have a right to respond to that.
Ms. Norton.
The second matter is more a matter of housekeeping, Your Honor, and it's really looking forward to the determination one day of the substantive matters before the court. Reference has been made today by Mr. Kuksal to an affidavit of Ms. Di Gregorio which was affirmed on the 21st of December last year. And I believe is been taking Your Honor to exhibits to that affidavit.
Yes.
We have the affidavit but not the exhibits. They appear not to have been filed on Redcrest.
They're not, that's not true.
Well, I'm sure you'll be able to get hold of them.
Well, I'd just like to make the request on transcript that those exhibits to the affidavit.
I will have to respond to this.
No.
The affidavit of the 21st of December 2022 sworn by Ms. Di Gregorio, or affirmed, I should say. And, similarly, we'd like to be provided with, served with the exhibits to Ms. Di Gregorio's affidavit of the 17th of October 2022. As I understand it, both affidavits are relied on by the plaintiffs in the substantive application, and we would like the exhibits.
All right, thanks. Now, Mr. Kuksal.
Your Honor, I have to.
Mr. Kuksal, I don't much care whether you've served them or you haven't at the moment. But can I assume that you will make copies of those available on request?
Yes, I have to respond to both issues.
Yes, but if you haven't served them then you should have, but you might have. They might have lost them. The point is, for some reason they don't have them.
That's a scandalous allegation.
Are you going to facilitate? Are you going to provide another copy of them?
Absolutely, but Your Honor, they're both. Let me raise this.
Thank you. No, that's enough of the exhibits. I'm not interested anymore about the exhibits.
I have to respond to what was said. What they're asking the court to do is not draw a Jones v. Dunkel inference. Firstly, and secondly, what they're saying is that they couldn't have responded to that anyway because they didn't have the exhibits. This is, again, a nefarious ploy to undermine the court's use properly of the evidence we have.
Okay.
It is, those videos were in the body of the affidavit.
All right.
It's a sworn affidavit. It swears to Ms. Di Gregorio witnessing the things as they're occurring. And then providing a link of a video.
Mr. Kuksal, you're boxing at shadows here. There was no objection taken to you showing me these videos.
She's saying that it's not credible evidence.
I said it.
She's saying that the evidence that was produced.
It's this fact that what she's saying is they don't accept that they've acted improperly.
Your Honor, they were required to file an affidavit in response.
Mr. Kuksal, they're just saying that they do not accept that they've acted improperly.
Okay, so then the other matter is that I have proof that they have been served with that affidavit.
Okay, terrific.
And I have already provided this court with proof.
Of the exhibits, yes.
That the registry was provided with the exhibits.
All right.
They're too large to be filed on Redcrest, that's why they're not on Redcrest.
That is part of the difficulty. They're so large they can't be easily circulated. But I am sure there will be.
And that's the court doesn't have a way of lodging videos through Redcrest.
I mean, nobody is accusing you, certainly today at any rate, of misconduct by deliberately in for some improper purpose choosing not to serve the exhibits. All I've heard from Ms. Norton is, she doesn't have them, or she can't find them or something or other like that, and they would like to have it made clear that that's the situation in the hope that that can be rectified.
And Your Honor, I also note that the transcript will show that earlier in the day she had said that that affidavit was not filed in this proceeding. It's only because I pointed to the reasons in which it is mentioned that she conceded. But now, one final thing, Your Honor. Literally, on the 18th of August, Your Honor had also asked me if I had, in fact, complied with an order that I considered to be indistinct and deleted the material that the order had required me to delete. That was putting me in a position where my right to not give evidence against myself, my right against self-incrimination, was compromised. And that was, again, something that shows partiality.
All right, thank you. I'm going to reserve on this matter, and I will be in touch. I will endeavor to get it dealt with this year, but I've got a number of other things ticking along. It's inevitable, I think, that if I don't recuse myself, then it's a matter of moving on with the other matters to be determined. If I do recuse myself, then things go back a step, I suppose, and some other judge has to take over.